On the last Saturday, Your Lordship asked about correctional home judgment passed by Your Lordship.
Correction.
Correction, Your Lordship, on the Saturday, Your Lordship wanted to see the correctional home judgment.
Oh, yes. Thank you. Thank you. Any appeal preferred?
Till now, I have not informed.
Till now. No. Yes. Call the list.
Pilot, may I be permitted to mention?
What you mentioned?
Pilot, I am mentioning for inclusion of restoration application, which was dismissed for default in the year 2020.
After vacation.
Right.
Sir,
Wait.
sir, I have mentioned my case was fixed in last Saturday, and last Saturday I am in a video call, but I cannot put the serial number. That's why I am not in a serial number 69. I cannot enter into the video conference.
In the list. It will appear what we have said.
No, but thing is that my SAT dated in 26 November. Before that, my review was on June of 10th in the 47 WPST. But I went 3 times for speedy disposal application rejected. High Court cannot give the direction, so we cannot anything hard. And the division bench will become mostly November in SAT. Before that, and it is a case of appointment. And the panel is published, they will be soon.
What do you want?
We want a review case. If the today fixed for the second half, that will be very much.
No, it is item number.
Item number 81 now, previously 61, and today is 81.
Yes. What is the urgency?
Urgency is the issue of appointment, and there is a review. There is a to Supreme Court and High Court's order cannot reflect that in the order. And
review application, it will be hard. What is the problem?
It is review. After the opening of the court, the SAT decided 26 November fixed the date.
Very good.
But thing is that from the June to March to till now, no division bench is present. So they said if division bench will come, or the case will not be heard by the learned single court.
Review you have preferred against which order?
This order of WPST 47 of 2023.
Against, in connection with the order passed by us?
Yes, sir.
What did we say?
You said that go to this SAT, and SAT will judge the matter regarding the Supreme Court and Apex Court order. The Apex Court order, Supreme Court and High Court, the order not reflected and not mentioned, not.
Okay, immediately after reopening, it would be placed in the list. Fairly at the top.
Sir, that will be in November. We will no ventilation appointment will be done. If it is
why you are coming today? You knew that November day we are closing down tomorrow. You are mentioning.
No. Our enlisted movement from the 1 week just move 69, 81.
Yes,
this
yes.
is from the 2 weeks that is
if the
moving.
matter has been fixed during the vacation, you could have told us 1 week ago. You did not tell us. Matter was called on. Saturday also it was called on. You did not inform us.
No, Saturday I came in video call.
That is whatever has happened. Saturday
So
the counsels were not appearing.
Okay, if you consider the case, because after the hearing, without hearing this case from the urine and the judge 3 times speedy disposal they rejected. We cannot receive the speedy disposal. Speedy disposal for SAT.
Who is your other side? Who is your other side?
States.
Who is appearing for this?
Appearing, sir, you appointed the advocate, Mr. AGP.
We have crossed the age
I already yesterday informed.
You are seeking appointment as a homeopathy doctor in a government hospital.
Yes.
So far we can.
Yes, sir.
Now you have crossed the age limit. You have crossed the age limit also. Upper age limit.
Yes. Then Supreme Court and High Court the verdict order.
Now,
the order cannot followed by.
Now you want review of this order. Review of the order passed in the writ petition. What about that early hearing?
Early hearing. If the hearing will, if the criteria fulfilled as per the Supreme Court order and the High Court order, at that time we are in 40.
So there another matter is pending before the tribunal and another matter before the High Court.
No.
So
before, at the time on 2011, we want High Court. High Court give a specific order for age relaxation. We are 2008. We are in 40. And at that time, the gross mistake, there is a tampering, there is a misviolation without publishing of panel. They have appointed. High Court Mr. Kollanjyoti Sengupta's
Okay,
court,
regarding merit,
there-
we shall enter into later on, but you say here one review petition is pending.
yes,
And another petition is pending before the tribunal.
before the tribunal.
For what purpose you have filed?
But tribunal cannot hurt the matter from the month. They are only mention stage from the 3 months. I already submitted and already written argument submitted. They cannot hurt the matter.
So in this matter, we cannot direct
No,
the
no.
tribunal.
Yes.
Kindly hear, in this matter, in review matter, whether we shall consider whether there is a scope of review of the order passed earlier. In this matter, we cannot direct the tribunal to dispose of as early as possible.
No, sir, before High Court, at first we went to SAT is closed. We used to do another court, Mr. Showman Sen division and Uday SAT's division
Sir,
bench.
are you not following what my brother is asking? First, listen to what is being said. What has been asked from you? We are in review. You have filed a review against our order. That review is pending. In the meantime, your main writ petition is not before the tribunal is not being heard. That is your grievance.
Yes.
That is your grievance.
No,
So
here
we
is
will
a
hear
clari-
it.
no, here is a
But
clarification.
that has no linkage.
No,
with
no,
this
sir.
issue.
Linkage previously I went the bench of Uday Kumar and that bench they gave interlocutory period to give application because website is not open. They give the direction to the SAT to give to physical application will be done in interlocutory period. They have done. Mr. Showman Sen's division bench. But the SAT cannot enter. But it is WBST. Then we went here. So the scope of the division bench.
You have kindly try to consider
Yes, sir.
or the scope is limited. Here we shall see whether there is a scope to review of the order passed by us earlier.
Yes.
Only this we are confined with this privilege.
No. In there is an interim order. We have
Yes.
we have demanded interim order. You have dismissed that interim order. That is the question
Your
review.
cause of action arose in 2008.
Yeah.
You have waited for 16 years. Still, you just wait 1 month. It will appear immediately after reopening the court.
Now,
Clearly at the top.
sir, thing is that if Supreme Court order,
Give the slip, you give the slip. After reopening, during this vacation, get prepared and then come.
Yes, call the
Lordship, may I permit to mention, Lordship, one application I filed 15 days ago that may be listed on next monthly list. I will supply the receive copy within our Lordship. 15 days ago, I filed one application for stay.
Is it in the list?
No, for listing next monthly list, Lordship.
Where is the slip?
Slip I will provide within 15 minutes, Lordship. 1 hour for the point. I will present it. Lordship, I'll ask the court of law to accept it.
Yes.
Grateful, Lordship.
No, it- এটা তো 12টায় ডাকার কথা, এখন ডেকে দিয়েছো কেন? আইটেম নাম্বার 2।
চলো আমার দোষ নেই চলবে তো চলবে চলবে
হিয়ারিং ম্যাটার
If Lordship takes up supplementary affidavit.
Hearing matter, we are making it further and posting it after vacation.
My lord, he will retire 31st October, my lord.
Huh?
He will retire 31st October.
Okay, that will be taken care of. Don't during a year. Only
There were limited questions, sir. There are only.
days are left. Hearing matter, we have to apply our mind. You are also busy to
Yeah.
go here and there. So we have extensively heard the learned advocate appealing for the respective parties. Keep that. At least this matter
But I appear for the respondents. But
Item number?
item 3. Let the
respondent.
petition.
Exchange
Let two,
petitioner.
let two wives. The second wife.
But the
Yeah,
petitioner, why you are
Yes.
doing this?
Oh, sorry.
Yes, so I mean, we are confused.
Yes, yes. But this is my.
Yeah.
In fact, during subsistence of the first marriage, the second marriage was contracted. Now, the service book, service book is blank regarding the family pension. That's why if all payment has been made, retirement dues has been made to the respondent, but he claimed tribunal also allowed interest. But that was not paid for the reason that the family description was lacking in the service book. Therefore, the delay occurred. Now, thing is this: the tribunal's order, they have filed contempt. I am told they are proceeding with the contempt, and tribunal is insisting for compliance of the order. So, I only submit if your lordship wants to hear this matter at length after vacation. Only thing I would be praying
So you satisfy us why you do not want to pay interest.
because the delay occurred due to non-furnishing of the family
It
details.
was which document you are saying?
Petition to the but kindly see my
Just. Page 9. This is the- It is put down to the-
if your lordship kindly takes page 47 of the writ petition, Lord, paragraph 8, the delay was due to this, Lord. Kindly see the respondent number 4, head of the office by letter dated so and so returned all documents submitted online by the applicant for mismatch of family details and non-uploading the name of wife as per service records. But that was the sole reason for the delay. The tribunal, Lord, did not appreciate.
When was his retirement?
Lord, he retired in 2020.
31st of August 2020.
Right. 30th August 2020. He
I've handed up, my lord, one list of dates.
Now, my lord, this is the sole reason which the learned tribunal failed to
No,
appreciate.
this is a letter post-retirement. This is 18th of December 2020.
Right. Because, my lord, the pension ought
There
to
was a
have,
mismatch of family details.
yes, because, my lord, two wives,
How do we know that? Where is the mismatch?
my lord, mismatch, my lord, your lordship directed me to produce certain documents, my lord, that I have, my lord, procured. If your lordship kindly have a look to this, my lord. Lord, kindly have a look, my lord. The once she described his wife as Kamala Raut. In 2024, my lord, he said that Moina Raut is my wife. My lord, without, my lord,
Which
taking,
page you are referring?
Lord, Lord, kindly see, Lord, page 4, 1, 2,
Yeah, have you given copies to him?
5.
Well, I'll
Lord,
just check.
I will just
Acha, page 4, yes.
page 5, Lord. Your Lord, kindly see, Lord.
2nd February letter.
No, this is from the service book, 2nd February, right? 2nd February.
24, yes.
Yes. Now, Lord, Kamala Raut, your lordship would see Kamala Raut described as wife. Then
Moina Raut came.
yes, next page. So this is Lord, the situation, Lord, which was submitted, Lord, on 26th August, just 5 days before retirement. That created all troubles, Lord. That created all troubles.
You ought to have processed the pension papers in terms of the rule 6 months ago from the date of return. You do not take such time.
No, Lord, the pension was payable immediately after retirement.
Right.
Now, Lord, the pension papers, Lord, ought to have been forwarded to the concerned authority by the respondent, Lord, within Lord, 6 months before retirement. Within
That
6.
you did not call for. Your first letter is of which you have annexed here.
Yes.
Your first letter which you issued, that is page 60. That is 11 days prior to return of the writ petition. Page 60 of the writ petition, page 59, you see, in continuation of our letter of 3rd August. He was retiring on 31st August.
Right.
It is requested to provide. This you ought to have sought out earlier. You did not give him sufficient time.
No, Lord,
So the tribunal said that he is not responsible because you did
No,
not
Lord,
apply
Lord-
Rule 21. Second marriage, no proceeding, no suspension, give him the benefit.
right. Lord, actually, Lord, things, Lord, occurred, Lord, after at the time of, Lord, his retirement, because the concerned authority, Lord, came to know that there are anomalies in the service book. So, Lord,
August 20.
admittedly, Lord, he has been paid everything.
ও রিটায়ার করেছে 31শে আগস্ট 2020।
But admittedly, he has been paid.
Yes, Mr. Roy. Mr. Roy.
My lord, Lordship has seen, man. Here on the earlier occasion, my lord was pleased to, my lord, direct, my lord, me so that I take instruction from my client, because there has been, my lord, direction from the learned tribunal so that the interest is paid on everything.
Hmm.
So, my lord, I have taken instruction from the client and he says that if it is on the gratuity only, he is satisfied with that. And lordship, it is subject to correction of my learned senior as well as my this honorable court. My lord, the gratuity which has been admittedly withheld, my lord, since 31st of August to my lord, 9th of January 2024. That is, my lord, completely for the reason of there. My lord, because lordship it has already fallen from your lordship, my lord. 3rd of August, my lord, they asked for the document. Immediately, I have given the document. And after that, my lord,
Document whose name you mention as wife.
by Mina.
Then what is page 90 of the writ petition? Not 90. It is 93. 92, sorry.
My lord. So, my lord, it is this particular details of the family, my lord, was previously mentioned by me.
Right.
Previous at the time of employment.
So did your first wife die?
My lord,
You did not say that. You took a ground that there is a mismatch of name.
my lord, yes.
That would have succeeded had you not supplied the marriage certificate, which is in the very next page.
My lord, yes.
So then you have suppressed the fact that you had married second time.
Subject to
And
lordship.
you were not only that, you have obtained loan in the name of Tumpadai.
My lord, there is no such proceeding, even at the time of my lord, my
Really?
retirement.
You are practicing fraud, Mr. Rai.
My lord, that would be established subject to correction,
No,
my lord, only after.
here and now it is established. Page 93, Khan.
My lord, I've seen
So
that.
you should have pointed that out to us. We had took the trouble, no assistance, nowhere. We had to go through the file.
But,
Now we find in their reply, they took a statement that on the name of Tumpadai, you availed GPF's loan.
but
Tumpadai was never your offspring pursuant to the first marriage. We were desirous of allowing your application. But when the record says something else,
about this Tumpadai and
please
loan,
come
my
to
lord,
93.
that my lord was I'm sorry, my lord, I did not also find from the
No, you
their contentions.
consciously took the point, Mr. Roy. This is
the
Tumpadai,
certificate
page
of
9
marriage.
page 93
Is the certificate of marriage, my lord?
with Moina.
Yes, my lord.
This marriage was on 16th April 92,
My lord.
second paragraph.
Yes, my lord.
Now you name the schedule of offspring, you refer to Tumpadai. Now kindly come
Yes,
to page 92. There is no Tumpadai in your schedule of offspring.
Yes, my lord.
There
Then
must be some unexplained delay on their part in disbursing the gratuity amount or other.
My lord, subject to correction, my lord, the gratuity amount.
Is caused due to your fault or due to your action.
My lord, subject.
Whether they can be penalized.
Subject to correction, my lord, this gratuity amount only, my lord, could have been withheld. Only, my lord, if the disciplinary proceeding would have been initiated or a cause was issued to have been.
You are before the equity court, Mr. Roy. We must be satisfied about your conduct.
My lord, about
Kindly come how you have proceeded. Correct us if you are wrong. Kindly come to page 44. Your statement in paragraph Roman 5 of your original application.
yes, my lord. Pension processing of the applicant was initiated in August 20 when retirement of the applicant was due on 31st. The documents as to the details of present family with joint photograph was first called for by 3rd of August. As disclosed from communication of 10th of August, the applicant submitted all required documents with joint photograph with Moina Raut as wife.
Moina Raut, his wife.
Yes.
This tally with page 93.
Yes, my lord.
You admit that you had a first wife.
Yes,
Moina Raut was the first one. Has she died? If she has died, produce the statement. And if you have after death, you have entered into marriage, no problem.
My lord,
that was intimated to the other.
My lord, subject to correction, my lord, if this particular situation, my lord, would have arose, at least, my lord, 3 or 4 months before the date of retirement.
No, we understand that, Mr. Rai,
Lord,
but there
I
is
also
an
could not get
ingenuity, Mr. Rai. We are in judicial review. If the record shows that there is a prima facie ingenuity, why should we give the taxpayers' money to you, 8% on gratuity and other things? Satisfy us that no, these records have been wrongly interpreted and they have not initiated any proceeding at any time, though there was an obligation on their part. So tribunal has rightly
My lord, my only contention before your lordship, my lord, gratuity is not, my lord, it is definitely, my lord, not a bound. I tell your lordship, my lord,
No, there is no dispute.
but I
You
just
satisfy our doubt now.
because this
You tell us that your first wife died. Tell us.
but,
There
that
is
I
no,
cannot
there is
that
no,
I
on
cannot,
the
my lord,
contrary,
say.
you have taken a stand that there was a mismatch of names. Where did I find? I think somewhere it has been stated in your original application.
My lord, it is, my lord, it is their office order also, my lord, that is there.
No, no, you stated. I do not find that line. Hey, there. Page 45. Respondent by communication raised a question of mismatch of name. Then you furnished an executive magistrate certificate, I think. সেটা কোথায় যেন পড়েছে? এই mismatchটা না।
My lord, I have
Mr. Roy, your junior ought to have gone through the records. Where is that executive magistrate certificate?
let me
এটা
see.
দেখতে না মামলা করছে।
Let me see. Executive magistrate certificate. না প্রডিউস করেছিল তো প্রডিউস করেছিল অ্যানেক্স এমনি রিট পিটিশনে অ্যানেক্স আছে নাকি
My lord, my lord, even the pension payment order, my lord, after after the order of the learned tribunal was passed, my lord, the pension payment order was issued. So, my lord, pension payment order, my lord, there is no name of any wife.
That is because of this dispute.
So this is why, my lord, I've already
You have got the benefit. We are only on interest.
interest on the gratuity only.
Only on the interest on gratuity.
My lord, I just beseech your lordship, my lord, that what has fallen from your lordship, my lord, my lord, I completely bow down, my lord. Only one thing, my lord, lordship will kindly appreciate, my lord, whether this has been a misconduct on the part of the authority, the incumbent, my lord, that whether he has suppressed or whether.
No misconduct. That is why you are being given the gratuity. We are not interfering with that. You have been paid your gratuity. Here the question is interest.
My lord, I just beseech your lordship, my lord, if there has been no misconduct or no proceeding, my lord, the names of the wife, my lord, it would be important.
Give 3 names of my wives to
It would be
employer.
important at the time of family pension, my lord, for which I have already
Why
initiated.
you are not expressing that I didn't do this? Come with clean hands, Mr. Roy.
My lord,
This is a basic requirement. You should come with clean hands. You have not said so. How can we help you? Tell us.
my lord, I have the contention of my the incumbent, my lord, lordship will see from the original application that since this. But if lordship kindly take the trouble, my lord, to see the pension payment order once.
We are staying the operation of that interest part. Come with your evidence. The present writ petition has been preferred.
Yes, my lord, what troubling is me, my lord, is that because this marriage has happened in 92. And after this, my lord, it may be the case, my lord, that this incumbent has informed the authority.
Show us that.
That question, my lord, did not come. I did not produce this kind of documents previously. This is only, my lord, I just, my lord, presume.
Produce then in
It's only I presume.
Mere presumption.
Because, my lord, if it is not, my lord, they would have started a disciplinary proceeding. They did not, because they knew that they already knew these facts. And they
So
did.
it is not your duty to correct state.
I'm sorry, my lord. I was just trying to, my lord, mean that it might be the case that I have already performed my duty.
So how?
Because this is not evident from these records, because this has never came up.
How will it come up, Mr. Rai? I give my name as X. I conduct a second marriage. I consciously will not give my second wife's name. Then you created a problem.
So
You
that would have
obtained
been
law.
definitely a misconduct.
So you have released pension and gratuity.
Everything.
Everything.
Yes, but
Everything
even
without interest,
after
everything
the
has been.
after the order is passed, because they have accepted the order of the learned tribunal.
Because
Because they withheld the entire, my lord, retirement part. Now they have accepted.
That interest part on.
No, they are agreed by the entire part that I would not have been given the gratuity as well.
No.
Yes, my lord, your lordship will kindly see the writ petition.
Pension, gratuity and all,
No,
all of
that they have accepted after the tribunal's order was passed. They were agreed. Lordship sees the writ petition. They were agreed by everything. But even in spite of filing the writ petition, they have disbursed. So they have accepted that part of the learned tribunal. The part of interest, my lord, that right now they are.
Your entitlement, what about the cause of action to claim interest arises due to delayed payment?
Yes, ma'am.
Huh?
That case I made out in the tribunal.
Ultimately, they have paid.
Yes.
They have not withheld showing any reason. They have paid. But it is a delayed payment.
Yes.
Give rise to a claim of interest.
My lord, that I have already made out in the tribunal.
Now,
My
this
delayed.
delay, you have also some contribution to this delay.
That I cannot.
They
My
are
lord,
not be held to be solely responsible for it is
That is-
due to administrative
that-
reason or any other.
subject to
You
subject
will
to.
be in problem, Mr. Roy. If affidavits are called for, if it is established that you have practiced fraud, you will be in problem. That is why we gave you time.
But lordship will
Because
kindly.
suppose
Yes.
after hearing on the issue of interest,
Yes.
we hold that you have misled them and you have tried to take advantage of their ignorance, then the clock will be set back. You will be at the threat of losing or forfeiting your issues which you have already got.
Or that could have been done, my lord, only when the disciplinary proceeding could have been initiated by them.
Necessary. If we find a
Subject to
person
correction.
has practiced fraud, why should we extend our discretionary benefit to them? Not necessary at all. Try your luck. You're wanting evidence. We will give you evidence, but you will suffer that issue.
But
Ashok,
as your
the
lordship.
present writ petition has been preferred.
trained to proceed with the contempt matter.
Come on, stick
Because
to this.
We have stayed,
okay, I'm grateful.
we have stayed the operation.
Yes, all right. I'm grateful.
Grateful.
Extremely grateful. My lord, I'm for the writ petition, my lord.
I am appearing on behalf.
I'm led by
Named
Mr. Kolal Vasu.
By Mrs. Chandriala. My lord,
Yes, what is your instruction?
My lord,
Lord,
my client
may-
is present, my lord. He has inquired from the department, my lord, from his office, that the present presenting officer is not having any
Not
LLB degree,
any
my lord,
law degree, my
any
lord.
law degree.
So nothing remains to be decided.
Yes.
My lord, only, my lord, lordship may kindly clarifies, if situation arises, I can raise my plea, my lord, in terms of this office memorandum, which was not considered by the honorable tribunal.
We are not stopping you
My
from
lord,
that.
No, my lord, the tribunal's order is stopping me, my lord.
Mere anticipation.
No,
mere
my lord, possibly not, my lord. The tribunal, honorable tribunal has
This
decided.
matter is
Whom have you appointed?
My lord, Bimala A.
infectious, my
Tolani,
lord. And
APO.
new Mrs. Srimati Bimla A. Tulani is not he has not the law degree, my lord.
Are, where is the affidavit you are showing?
Affidavit.
Miss Alam was showing us a, have you given copy to him?
Yes.
Yes.
হ্যাঁ, সেটাই তো একটা এভিডেভিট করে নিয়ে এসছি। Where is that?
Affidavit, I have sought the affidavit.
The
give it to
opposition.
us.
Yes, opposition, my lord, I have sought.
Affidavit in opposition, but this has
Affidavit
come
No,
after
that
that.
person has changed.
Yes, that order, my lord, a copy
Did
was
you get
handed
it?
over.
You get the copy of the order?
Yes, order, I was handed over a
Actually,
copy, not
this
by way
matter
of
is-
supplementary affidavit.
Do you have that copy?
No, my lord.
This matter is, my lord, infectious, my lord. The
Judge sahib, copy টা
previous
জজ সাহেবকে কপিটা দিন চাইছে অর্ডারের কপি।
They have appointed Dr. Kaushik Mukherjee.
No, Kaushik Mukherjee is the charged
Kaushik
employee, my
charge,
the
hai.
petitioner here in my lord, Bimala A.
Bimla A. Tulani, my lord, but she
APO.
has no law degree.
He is not a legal expert.
সেটা বলে।
No, they are making some.
She has no law degree, my lord. Actually, my lord, the matter is infectious. Like the
If your lordship kindly sees
Lenny
their
Kumar is-
opposition page 33,
has
the office.
We will say
Well-
it has become infractuous.
My lord,
infect.
And we will also record that somebody else have been appointed who, according to both of you, is not a legal expert.
Fine.
So the question of further decision in the
Further.
matter is not legal.
my lord, only one humble prayer, my lord, lordship. I do not know whether this presenting officer will continue with the inquiry or till its logical conclusion or not. That I do not know. If my lord
You are
subsequently,
unnecessarily apprehended.
no,
Yes.
possibly my lord, may kindly sees.
So we are not deciding that issue.
My lord, the honorable tribunal has already decided the issue, my lord.
That is in respect of a person who was, according to you, a
Yes,
legal expert.
but not considering the office memorandum dated 23rd July 1984.
For what?
For my lord, it says, my lord, lordship may kindly sees
23rd March 2020.
23rd July 1984.
Where is that?
My lord, lordship may kindly sees their affidavit in opposition, page 33.
Yes, what you are showing.
Lordship, this is. May I read the first paragraph only? The undersigned director referred to Rule 14.8a, such and such, which provides inter alia that a delinquent government servant against whom disciplinary proceeding have been instituted, as for imposition of a major penalty, may not engage a legal practitioner to present the case on his behalf before the inquiring authority unless the presenting officer appointed by the disciplinary authority is a legal practitioner or the disciplinary authority, having regard to the circumstances of the case, so permits. It is clarified that when, on behalf of the disciplinary authority, the case is being presented by a prosecuting officer of the Central Bureau of Investigation or a government law officer, such as legal advisor, junior legal advisor,
there are evidently good and sufficient circumstances for the disciplinary
We are
authority.
not deciding the issue,
My
Mr. Banerjee.
Lordship kindly sees the tribunal.
Arre, why you are inviting us to decide?
No,
The
my lord.
person is not there.
Person is not-
My lord, this is
Here,
Lordship.
in anticipation, we cannot, we have stated that in anticipation or in apprehension, court cannot pass in.
My lord, possibly the tribunal observation, the online of that statutory rules do not permit engaging a practicing lawyer in the departmental inquiry. This will debar me even if a situation arises, my lord.
How?
If my lord subsequently this
Where you are reading?
my lord, the tribunal's order, impugned order,
Huh?
paragraph 7.
Yes.
This is paragraph 7, my lord. 7th line, my lord, paragraph 7.
Yes.
My lord, it can be admittedly be seen that the presenting officer admittedly is not a practicing lawyer. The statutory rules do not permit engaging a practicing lawyer in the departmental inquiry. The judgment is reliable such and such. So, my lord, the Honorable Tribunal has not considered the 23rd July office memorandum. So, my lord,
For what? For your claim?
Yes,
that the person who is there is a legal expert.
factual scenario has
Stated
changed.
that he is legal practitioner, he does not arise, a legal expert.
Yes. So, my lord, this factual scenario has certainly changed. My lord.
My lord,
Take
I
your
have
seat. Take your seat.
maybe, my lord, that
Get
we have
back
lost.
breath, get back.
My lord, page 33 has already been placed before your lordship, my lord. Lordship,
Nothing has been placed. We have been
Oh,
told that
no,
the
yes.
officer has changed.
officer has changed. Now, my lord, before the tribunal, my lord, honorable tribunal, my lord, we replaced our reliance, page number 33, dated, my lord,
We decide now.
No, because the tribunal has decided, despite the existence of this circular, tribunal office memorandum, the tribunal did not consider it, did not discuss this issue, and tribunal omitted this issue and decided the right between the parties. Now today, on account of this, this submission made by the respondent, that the situation has changed, and my lord, all contemporaneous stone, my lord, this is absent today. Even then, my lord, the parties are bound by the decision that has been rendered by the tribunal. In the future, if they change their stand,
We will say we have not decided that.
no, then, my lord, kindly give me a liberty, my lord, that in the event, my lord, this situation occurs, I shall have a right, my lord, to come before your lordship's
So
court.
that is what we are saying. Your junior was insisting us to go to 84 circular. Arre, we will record that some else personal, as such the matter has become infructuous, and we will say that observation, that issue is left open. If in future, if it
Yes.
so
No,
happens.
I stop here, my lord, deeply obliged. I'm sorry.
Ashok, the present read petition.
Infectious.
this
No, no, let his senior
landed
come.
council submit.
All the
Tribunal says we do not find any material.
Yes. Call your senior. Please wait. You wait. You please wait.
Lordship, I appear on behalf of the state, your lordship, the supplementary affidavit in this matter, your lordship, on the last occasion, your lordship was pleased to seek for the reports, your lordship, of the department, project department. This is pertaining to that temporary data entry operator, your lordship.
Yes, yes.
Your lordship will kindly see page 18 of the supplementary affidavit, your lordship. All the reports have been annexed, your lordship, to the supplementary affidavit.
Just to be decided, Mr. Ghosh, prior to vacation. It is
No, but opposition affidavits all are completed. Only point is regard to be decided by your lordship is that whether a contractual employee against whom allegation is that he has not
Non-performance.
non-performance, not non-performance, he has not done his duty properly. He has the words are very specific. May I-
Sure, on the last occasion, allegations were also made
The
that we have not.
Abstentionism, disobedience, lack of
Yes, your
integrity,
lordship, advance copy has been served,
lack
your
of
lordship.
discipline, adamant attitude. These are the allegations against a contractual.
Forget about that. Now your brother is functioning in that
Yes,
post.
your lordship.
No, the brother has been transferred.
He is
He
working
is
as
also worker, or he is also
When
employee.
was he transferred?
But he is transferred on this. In my reply, I have annexed the document. You also can look into my written reply.
Your
Was
lordship,
it after
subsequent to
our
his
order?
dismissal, he were.
Was it after our interim order? Interim
No, your
order?
lordship, before the
Was
matter was
transferred on
even filed.
5th of October 2021.
5th of October.
2021, your lordship.
21.
Yes, your
So
lordship.
why didn't you disclose that fact to us?
Well, it was not known to me.
Your brother is working.
No,
I
he
don't
was not
know.
appointed. He was
So
not
you are
appointed.
not staying with your brother?
No, we are not staying. He is not appointed. Well, kindly consider
You should have told us that.
there are total
No,
number,
no, you should have told us that.
but it was not known to me.
Then why? Why? What is the reason? You invited us to go into the merit. We passed an interim order to your favor. When they came up with this point, now you're seeing my brother was saying, yes, he was given transfer. You should have told us. You have suppressing the fact you have obtained an interim order from us. This is not proper.
But I'm not, there's no intentional suppression or
This itself shows your client is not sincere. 2024 July, when we passed the order, you did not tell us that the post is not vacant. Somebody else has come and joined you.
No, you are working in Baripur.
in Baruipur.
Now, Kamal Vishwas, your brother
was-
has also been
He was appointed.
posted at Baripur.
He was,
Yes,
kindly see page 16 of my reply. He was posted at Alipur Women's Correctional Home. Thereafter, he was transferred to Baruipur.
Immediately after his dismissal, Tamal Bishash was appointed
Kamal Vishwas was appointed
in his
when?
place. After his dismissal, your lordship, in 2021.
After his
Yes, your lordship. After his dismissal, he was posted in his place since 2021, and he has been working in that post since then, till date. Your lordship, even
Appointment, fresh appointment. These are
your lordship,
transfer-
allegations have also been made that we have not given notice to him. In the supplementary affidavit, we have annexed all the relevant communications
not-
and
ma-
documents where we have repeatedly requested him to join service and stay at the barrack. We have given him options for
Where is
online
your
work.
where is your IT committee report?
Your lordship, page 18 of the supplementary affidavit, your lordship. The
Supplementary.
project in charge's report and the DIG's report and everything is at the other documents is from page 10. Your lordship, the project in charge, chief controller, nodal officer of e-prisons report is at page 18, your lordship.
This you have replied to this?
No,
Your
never I've been given this document.
Your Lordship, this is the advance supplementary affidavit which I have served in
Supplementary
advance.
affidavit, my lord.
Your Lordship was please.
This letter was never issued to me. No show cause, no departmental proceedings.
Your Lordship, the regulations do not call for the same in case of temporary employees, Your Lordship. Your Lordship, the regulation he relies on does not
You appointed as casual.
yes, Your Lordship.
Contractual.
Contractual casual.
My case before your lordship is that a contractual employment, if it is stigmatic in nature, the termination, there should be a departmental proceedings.
It's not required. Situation has become different
My lord.
following your father's engagement.
Brothers are not engaged. Well, he was working since 2005.
No, no,
Lordship, the
No, no,
particular
this is
post is
completely
filled up.
neglect. Kindly see my reply.
He's
But kindly
working
see
at
my
the
reply.
Paripur Correctional Home, Your
But
Lordship.
he
In
is
his
the
place,
data
Your
entry
Lordship.
operator. He was appointed long
And
back.
again,
He
Your
was
Lordship.
posted in Alipur since I have been
But his post
dismissed
is
from the.
filled up, Your Lordship.
Since he has dismissed from my, I'm dismissed my service, the post was running vacant. He was transferred. That was the order. He was transferred. The post is still lying vacant where I was working.
Actually, if you are not satisfied with the,
Your Lordship.
actually, you are not satisfied with his performance. Now, somehow during COVID period or any other period. Now you could have.
Your Lordship, may I, Your Lordship, answering Your Lordship's queries, may I submit one thing, Your Lordship? Here, the petitioner seeks to blow hot and cold at the same time. At same breath, he relies on P5 22nd July 2023, a regulation which guides their the data entry temporary data entry process operators, and then again devoid of such rules, against such rules, he says he needs to give hearing. He needs compliance of clause 12 at page 27, which seeks for a report by the project in charge. Your Lordship, I have already produced such reports. On the basis of such report, a temporary employee who is not entitled, whose entire appointment is on temporary basis and contractual, seeks a discipline. 55, Your Lordship. 55. Page 55. Report 35. Actually, kindly gives me a moment. My brief is not paginated by then. 55.
30th June 2023.
30th June, Your Lordship.
You are referring upon in
53.
view of adverse reports, middle of the order,
30th June, Your Lordship.
middle of the paragraph.
Yes, Your Lordship.
In view of
That has been annexed here to page
It
10.
was very 6th of May.
Your Lordship,
6th of May, you have annexed at page 18. Where is
Yes, yes.
14th of May?
14th of May, Your Lordship, page 10.
Page 10 of your supplement.
Supplementary affidavit, Your Lordship. This is the order. The recent detailed order is at page.
And where is this opinion of IT cell envisaged in note 8 of file number such and such?
Your Lordship, I can.
That is page 13.
30.
Your
One
Lordship, page 13.
that is
Of the
dated.
supplementary evidence.
Yes.
Yes, Your Lordship.
That is dated 10 June 2023.
10th June.
23.
Page 13, Your
13,
Lordship.
note 8.
Note 8.
What is the remark?
It is stated that no recommendation has been received from
From
NIC
NIC
Kolkata. Sri Tilok Biswas was dismissed from contractual service by ADG Correctional Service due to irregular attendance. He was warned by the Superintendent Baripur CCH for several times, but Sri Vishwa did not care about the responsibility, submitted for information. 10 June 2023.
Your
line
Lordship will
start with,
also,
it is stated that no recommendation has been received from NIC Kolkata.
NIC Kolkata recommendation is not required in
No,
terms
Your
of that.
The regulation says,
Regulation says something else.
regulation says,
Yes.
Your Lordship,
Wait, madam, wait.
sorry, Your Lordship, extremely sorry. Page
Based on
27,
recommendation of IT department or NIC project leader.
or the
or the
project,
project
leader.
in charge.
So who is this? Page 13.
Your Lordship, this is the note of the, where the
Nodal
meeting, nodal officer.
We are inviting affidavit from them.
Affidavit has completed.
Yes, Your
The
Lordship.
supplementary
Supplementary.
Now, regarding supplementary, I don't want to use any reply.
And Your Lordship,
Because I say that this supplementary shows the motive behind the issuance of the order of dismissal. The order of dismissal is says, just 3 lines. My order of dismissal indicating abstention, disobedience, lack of integrity, lack of discipline, adamant attitude of Sri Vishwas, which all are detrimental for maintenance of ideal atmosphere at workplace.
What do you are saying you will not use a reply to the supplementary?
Yes, ma'am.
Then 30th June 2023, this order was passed on the basis of those recommendations.
Those recommendations,
So those have been brought on record.
my lord.
And if you do not use a reply, how you will defend your case?
Kindly consider my
We will consider later. First, we will record you do not want to give a reply to this.
because kindly consider, because these report, the supplementary affidavit shows the motive behind issuance of this document.
Motive will come
The-
later.
the-
Motive, they have produced the records on the basis of which the termination letter was issued.
That my case is that, my lord, in my reply, I categorically said my case is that they have taken steps. These documents were never supplied to me before.
What has been averred in the supplementary affidavit, or what documents has been annexed there are being undefended
My lord,
from your part,
my lord, true.
from your part.
Yes, my lord. Yes, my lord.
And
Subject
so
to
it
correction.
constitute to have been admitted by you.
My lord, kindly consider only one thing. These documents were first time produced before this honorable court. First time. These
Hence,
these documents required to be given to me so that I can reply and a departmental proceedings can be initiated against me and appropriate order may be passed. That is my case.
entitled to claim that a full form disciplinary proceeding should be initiated against you, though your status is a contractual employee, since they have used that some misconduct, some term which can be
Stigmatic in nature.
defined to be a stigmatic nature or misconduct. That is the matter decided.
Yes,
is
my
to
lord.
be decided by
Yes,
the
my
court.
lord. That is my case.
It is only your case
Yes, my lord. It is my case.
that they have used some, they have dismissed or they have removed from you, raising some allegation. And they have not given any opportunity to defend.
My lord.
It is there.
Yes, my lord.
So, whether you will give reply or not.
No, but I don't want to give you, my lord, I only want to rely certain judgments. Just 2-3 judgments.
In course of hearing, comma. When did you file the supplementary?
Your Lordship, advance copy was served on Friday
Friday
itself.
We did, we gave you a leave.
Yes, Your
And
Lordship,
there is
there-
no order for supplementary affidavit. Your lordship
affidavit,
has
but your Lord-
directed them to bring the records.
record. So if I choose to file a supplementary affidavit, bringing on record.
Like in course of by an earlier order dated pursuant to our
But I'm appearing on behalf of the petitioner as a case for restoration of the this writ petition, my lord. My lord, writ petition has been made against my lord district judges on a judicial order in a suit for declaration. And on basis of that judgment, we had been at the BLR office to correct the record of right. But the BLR, my lord, refused to
DL,
grant
yeah,
thereafter
how many
up to-
days delay?
Delay, my lord, for the delay.
My
You
lord,
are for whom?
I am under.
Where is your
My
service?
lord, I am not in.
My lord, I have submitted the affidavit of service.
I cannot. Nowadays I have to vote. দেখতে পাচ্ছি না।
কোথায় এভিডেভিট অফ সার্ভিস দিয়েছে?
The order was passed on 21st September 2023. And we had filed the application on 11 December 2023. And it has come to our knowledge on 7 December 2023.
There are private respondents also.
Yes,
You have
my lord.
served them.
Yes, everyone.
You have checked
Both
up.
to the lawyer as well as to the private respondents.
Who is your
State for the state. Have you served upon the state?
On last Saturday also, we had intimated the state,
who is appearing?
Mr. Somnath Ganguly and Mr. Shukalpu Shil.
Somnath Ganguly was here just now.
Yeah.
We had sent him an email also, and we intended to submit a letter, but the office was closed on Saturday. So we had sent him an email and we had informed him also through WhatsApp, through SMS.
Oh, you know Mr. Ganguly.
But we had called him today morning also, but it was not replied.
You have sent to secretary to Nomano.
No, to all the respective, to all, everyone.
But whether you have served upon the
All acknowledgements are there.
advocate who entered appearance on behalf of the state.
Yes, the copy is,
I'll do it time to find out.
yes, my lord. Page number,
Comment reader, but where is
kindly
the
look at page number 9.
endorsement of receipt?
Kindly look at page number 9. Also, the original writ petition, we have served 2 copies. Everything again we served.
Is Mr. Somnath Ganguly just now? এক্ষুনি ছিল ছিল। Do you know Mr. Somnath Ganguly?
My lord, personally, I do not know him, but I had called him. Miss Ganguly had
Please
called.
call him court
Okay.
once.
Okay.
Pass over.
পাঁচশো ঘর
And each time for the applicant. This affidavit of service, I have served on all the respondents. This is an application against the order passed by the learned tribunal. The last annexure.
Annexure P15 আমার কপিতে নাই
Last
না না দেখুন
লাস্ট একবার শেষের দিকে শেষ কথা
এক্সেপশন আছে এক্সেপশন টু দ্য রিপোর্ট নাই নাই
Well, this is for appointment or admission?
appointment.
Appointment to the post of?
The
librarian
the post of librarian.
Yes.
Or if you lordships go through the order passed by the learned tribunal.
If 10 marks would have been awarded, then also you would not have come with
My lord, that is not my case. My lord, the observation made by the learned tribunal, it was admitted. In master degree, there is no marks. Mark was not given. Mark was not given.
That is because you did not upload that document.
That is, my lord, if you lordships kindly come
Had
to
not uploaded, then how?
uploaded, yes, kindly come to my application. No, application.
The selection process of which year?
2019
That is 2019.
2019 your lordship.
19.
2019. File your affidavit, Michelle.
And moreover your lordship I have received the order of the SAT now they had forgotten to annex it and
I'm sorry.
ঠিক আছে
Only to reach.
and it's all right
What order?
none order of the
order-
SAT was not
order
there
was
I have
not-
just received a copy
I
just now he
here
has
copy
given
I have given.
doesn't matter
That was not annexed.
Hard Mr. Salah.
ঠিক আছে
For the petition. See now. I am for the petitioner.
I am for the private respondents, respondent number 4 and 5.
But my prayer for early disposal of the tribunal application, I am the Thika tenant. Private respondent is my Bharatiya. I file an
When
application
date has been fixed?
and after 1 year. Kindly see this matter was
August 2025.
I've
Yes.
told Miller Mr. Shuman Shingu to represent the state in this matter. He's on his legs in some.
Go and file a preponement
Appointment
application.
application.
Dismissed as withdrawn with liberty.
Liberty to file it.
In that even if I withdraw this application, that will give another liberty.
With liberty to file it.
Then what happened?
And the event,
If I
this
kindly
application is filed,
consider
like
kindly consider this aspect. If I file an application, then that application will I have to mention. Then they will fix a date for hearing. We are dismissing your matter. Choice is yours. I am praying. You cannot claim to imposition of further conditions. You have to decide. I don't find any reason to interfere, but we can give you a leave. Now it is your choice. I approach before my lords. The bench is functioning. Now the only thing is after 1 year, after admission, the date has been fixed. Then my lord pass the necessary order. This is not a case, what member was.
No, tribunal may have many matters in its docket. But question is, you satisfy us why we shall ask the tribunal to give priority to this matter over our other matters.
Now, my respectful submission, in this there is no the member is available. The bench is now
Now
functioning.
in land administrative tribunal there are members.
Yes,
At least 4 members are there.
this fourth bench regular member is there. The learned fourth bench, the regular member is there. Now, the bench is not functioning for the full days. If the bench function in the full days, that matter can be took up. And in the instant matter, I have the Thika tenant. I file their private respondent of the Bharatiya. Under the new act, I file a eviction suit on the ground of default, reasonable requirement and subletting. The learned Thika controller rejected my application. Challenging that, I approach before the tribunal under this act, new act. So there is some urgency in my case also. They are the default. That from documents it appears. That is the merit of. Have you filed your opposition?
You should no, I
Tribunal? No. The tribunal, no.
only the private respondent has filed the written objection. I have filed from the repetitions.
No. As per the last direction on 20th August.
No, not so.
Then why you are not filing?
You withdraw with liberty to file application for preferment. In the event such application is filed, tribunal will consider the same.
Certainly, I shall obey my lord. You come with that instruction whether when they have prepared the opposition or not. Otherwise, we will ask the tribunal to not to give you any further opportunity. That 6 weeks have already expired. Come with that instruction, talk with your lawyer there. Then we can we can declare. We will take that on record and then we will.
Lordship is keeping it on after vacation.
1 week after vacation.
1 week after vacation.
After vacation.
Party landed advocate appearing for the petitioner. You're for appearing for?
I'm for the state miller here.
I am for the private respondents, my lord. 4 and 5.
এরম লিখে দাও in course of hearing
Lord, in this matter,
7, my lord. My learned friend has
Wait,
come.
Mr. Bhattacharya, we have called one matter.
Lord, item number 10, Mr. Bolailal Shahu was appearing. Mr. Arif Ali had 1 week.
1 week after.
I'm grateful. Lord.
Yes, 11.
Item number.
You're for the petitioner.
I am private respondent.
But I appear for the state respondents.
No one appears on behalf of the
I
petitioner.
appear for the petitioner, Lordship.
Instruction reached for the sir.
You are for the petitioner.
Lordship. এই petitioner before your Lordship, Lordship.
লম্বা ডেট দিয়েছে শর্ট ডেট চাইছে তো
এদের মাধ্যম ছেড়ে দিব টেকেন ফর
জুলাই 2025 রেখেছে
Petitioner purchased the land from the decree holder. From the decree holder, my lord.
early hearing.
earlier.
And not only this, my lord.
No, the
Early hearing not a position.
point of maintainability is yet to be decided by the learned tribunal.
The tribunal said that
14 July 25.
nothing in the merit of the case, my lord. But tribunal said in the
No. Tribunal does not say.
finally see the
I-
the order improved, my lord.
It is
Order, my lord.
vesting has not been challenged. He post-vesting purchase. 67 he purchased this land, 87. And 24 he made application for.
তোমার কথাটা পরে হবে তুমি
Okay, in the month of it was land was vested under Estate Acquisition Act.
Acquisition Act vested was made.
1953.
suit, my lord, suit filed for declaration of title.
Now you have
For declaration of title, my lord, it has been decided by the
section 3 says notwithstanding anything, any other law, decree, judgment, this act will be applicable.
57B also bar.
57.
57B, West Bengal State Acquisition Act, is also bar. The civil court has bar to decide the questions, my lord, to vest.
Subsequent judgment. But it has been decided long before, my lord, about, my lord, 70 years before, my lord. The title was declared and the state government and also state government lordship on the title.
শোনো বলে যাও সব
In every matter which we pass, early hearing, expeditious hearing, whether it would be possible for the tribunal to take up all the matter.
What tribunal said, my lord, what tribunal said here.
Now after vacation. 1 week after vacation.
1 week after.
It will possible. Restoration target.
One number. SP Bahari. Private respond.
Yes, Mr. Ganguly. You're opposing.
So far as the restoration is concerned, I leave it to your lordship, lord. I'm nothing to say.
Private respondents have been served.
Yes. We have, in the affidavit of service, we have mentioned it. And we have
What
also,
explanation have you given? In your section 5, what explanation has been
my
given?
lord, the advocate on record, Ms.
First,
Rao,
which paragraph?
it is
What is
in
your
page number 5.
Five.
My lord,
Mhm.
the matter was last heard on 22nd
Private
December
respondent,
2014. And thereafter, it was listed on 4th September 2023. Unfortunately, during that period, and few times before also, the learned advocate, she was seriously ill and was hospitalized
For 2 years.
for 2 years, and that continued for 2 years.
She's suffering from carcinoma.
She was suffering from carcinoma and was operated.
No. ওই যে জোড়া আছে।
Page number 4, paragraph 2.
बेटे कैंसर হচ্ছে পার্সোনাল আজকাল দেখি হচ্ছে পার্সোনাল পার্সে ক্যান্সার হচ্ছে হসপিটালে প্রায় আসা যাওয়া করে অপারেশন ব্লাড তো মিস করেছে 2014 আপনার ছেলে করেছে
What is the main matter about? What is the main matter?
Main matter is, my lord, in the title suit, a decree was passed in favor of the erstwhile owner, and during the pendency of the case, the petitioner had purchased the suit property, but the record was not corrected by the BLRO. Even though the BLRO had sent an observation to the DLRO that it may be corrected, but the DLRO has passed an order not to correct it. So the matter went prior to that, they were not doing anything. The matter was moved before the Honorable High Court on 2 occasions, and thereafter there was a contempt of court, and thereafter they passed an order rejecting the application. So the matter went for an appeal before the DLRO, and thereafter before the
First order in this petition was passed on 22nd December 2014.
Yes.
And matter was next taken up after 10 years. What were you doing? Is your petition.
Yes, madam.
So you did not take any steps for 10 years. You have not
Yes, my lord, we have.
What steps? Your last order was 22nd December 2014.
Yes.
Matter next appeared on 21st September 2023.
Yes, my lord.
What have you done in the meantime? On 14 December 22, you were asked to serve a notice upon the private respondents and to file a status quo order you obtained. And
Yes.
thereafter you slept.
No, the affidavit.
Thereafter you did not take any step.
মেনশন করা হয়েছে
No, we had mentioned it, my lord, but
Where is the mention? Where is compliance of the order? 22nd December 2014.
my lord, in terms.
Forget about anything. You obtained an order of status quo. There was a direction to serve upon private respondents.
Yes, we have served, and they.
Where from we will understand. This is a 2022-2014 matter. The court has rightly dismissed it.
No, my lord, the case was dismissed for
Please show
default.
us a document that you complied with 22nd December 2014 order.
My lord, at that point of we have communicated and we have filed the affidavit.
When matter never appeared, where will you file? Where will you file, sir?
My lord,
এই অর্ডারটা দেখাও।
সার্ভিস করা হয়েছিল
These matters are all status quo order obtained. Let us go to sleep. Let the matter go out of the list. We are not bothered.
সার্ভিস করা হয়েছিল
We have opened the page for you. See the last order of December 2014. At the beginning. At
Yes,
the
madam.
beginning, which you are holding. Yes.
My lord, we had filed an affidavit. If you allow me to check, my lord.
Not there. No such affidavit is there on record.
My lord, then I need to check my records. I remember we had served and there was an affidavit of service, and
Show us that. Yes, after vacation. A affidavit, you check up from your records, come and tell us after vacation. 1 week after vacation.
Chart. Milord, since Mylard's observation, Milord, was on the at the last one.
Place the case, Mr. Vasu. What is your case?
My case is, Milord, that I was denied the legal assistant, my lord, in a disciplinary proceeding, my lord. The order impugned, my lord, kindly, my lord, takes pen to page. The order impugned, my lord, of the Central Administrative Tribunal, my lord.
Yes.
Certified copy, my lord. This is dated, my lord, 6th March 2024. My lord, the disciplinary proceeding has been initiated and we prayed for, my lord, a defense counsel, my lord, because the inquiry officer is armed with the legal degree and, my lord, that is why, my lord, the basis of such prayer, my lord, emanates from, my lord, page 33 of the opposition filed by, my lord, my learned senior friend's client. May I take my lord's kind attention to this? 33, 23rd.
Just yes. Yes.
Now, my lord, it says that, my lord, it is clarified that when on behalf of the disciplinary authority, the case is being presented by the prosecuting officer, Central Bureau of Investigation, or a government law officer such as legal advisor, junior legal advisor, there are evidently good and sufficient circumstances. My lord, I wanted to place my reliance on this and the honorable tribunal while deciding this issue, my lord.
Understand what
My lord, I said, my lord, that it is, my lord, in subject CCS rules 1965, rule 14.8a, request of a delinquent official for permission to engage a legal practitioner to defend this case before the inquiry officer. My lord, it says that the undersigned is directed to refer to rules such and such of the CCS, Rule 65, which provides inter alia that a delinquent government servant against whom disciplinary proceedings have been instituted as for imposition of a major penalty. My lord, it says, my lord, proceedings have been instituted
where you reading?
Page 33
Of the opposition.
of the opposition dated July 23rd, 1984.
Yes, where you are reading?
No, I am reading from the, my lord, subject that it refers to, my lord, two rules, 1965 rules, Rule 14.8a, request of a delinquent official for permission to engage a legal practitioner to defend his case before the inquiry officer. It envisages, my lord, that what are the circumstances in which, my lord, a delinquent, my lord, is entitled, my lord, to get a legal, my lord, a defense counsel.
When
Having
on
a
behalf of disciplinary
Yes.
case is being presented by that one you are showing.
I am showing. So, my lord, my case squarely falls within
Or
this.
a government law officer. Please read that.
Yes, my lord, I said, my lord, that which provides inter alia, reading from the third line, from the first third line, inter alia, the delinquent government servant against whom disciplinary proceedings have been instituted as for imposition of a major penalty may not engage a legal practitioner to present the case on behalf of before the inquiring authority, unless the presenting officer appointed by the disciplinary authority is a legal practitioner or the disciplinary authority having regard to the circumstances of the case. So, having regard to the cases so permits, it is clarified that when, on behalf of the disciplinary authority, the case is being presented by a prosecuting officer of the Central Bureau of Investigation or a government law officer such as a legal advisor, junior legal advisor, these are evidently good and sufficient circumstances for the disciplinary authority to exercise his discretion in favor of the delinquent officer and allow him to be represented by a legal practitioner. Any exercise of discretion to the contrary in such a case, such cases is likely to be held by the court as arbitrary and prejudicial to the defense of the delinquent government servant. The Ministry of Finance, etc., requested to bring the contents of this OM to the office notice of all disciplinary authorities. Now, the Honorable Tribunal, my lord, while dealing with this issue, my lord, page 37 of the order dated 6 March 2024, my lord, omitted.
6 March, yes.
Yes, my lord, omitted to take note of this important authority, this circular. Kindly comes, my lord. Sorry, kindly comes, my lord. I will not destroy your lordship's valuable time. Page 5, para 39. Para 5 of the judgment. Page 39.
Yes.
Having heard the learned counsel at length, peruse the material on record, the representation or request applicant. Paragraph 5 of the imputed judgment.
Yes.
My lord, the conclusion part, heard the learned counsel at length and peruse the material on record. The representation request of the applicant dated such and such sent through email regarding taking assistance of an advocate as his defense assistant has been considered by the respondent. Same has been rejected. Video impugned order 28th March 2022, which reads and under Dr. such and such may please refer to his email dated such and such, request to engage to advocate Mr. Suman Banerjee as his defense assistant in the instant case.
Oh,
As per
that is why he is so worried.
no, 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 no,
Suman Banerjee
no,
what-
no, 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 Milord. No, no, Milord. Milord, a lawyer, Milord, we do not have.
That's why he is so
No,
nervous.
no, 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 Milord. I tell you,
He was
Lordship.
caught on the wrong foot.
No, Milord.
Uh,
Milord, his anxiety is genuine in the
so it
context.
is our anxiety that Mr. Banerjee will no longer be getting the brief.
Yeah,
No, no, no.
you will not get it.
No, Milord. Here, Milord, the tribunal has decided the issue without taking note of the circular. So, Milord, in the situation arises, the central government, Milord, takes the same decision. Then, Milord, it will be barred by res judicata, because if your lordship says that
Why you are apprehending that?
no, not apprehension. Milord, your lordships have taught us in apprehension writ lies. But in this case, Milord, no, Milord, kindly, Milord. In this case, tribunal has decided the issues between the parties. If the court says today, 226 court,
Where is that decision?
What is the decision?
paragraph 7.
Mr. Bose, kindly, that if
Dharan.
the presenting officer become legal practitioner, then the delinquent employee shall be entitled to be represented by a legal practitioner.
Milord, right. Today, Milord,
Thereafter,
right.
the rule
Today, in view of the changed circumstances, I possibly do not have any grievance. I agree. But Milord, kindly.
allow the
Yeah, sorry, Milord, sorry.
rule proceed further, stating that if any presenting officer become legal advisor or junior legal advisor, then it will fall within the discretion of the disciplinary authority to allow you to be represented by a person having legal background.
Right,
Tribunal has omitted to use this part.
right.
Tribunal says that the person was not legal practitioner, hence I shall not interfere.
Right,
It was the stand.
right,
Now the person who was appointed as a presenting officer, he has retired.
right.
Now that you have got no cause of action.
My grievance ceased to exist.
Your junior asking us to give and further order in the circumstances that petitioner shall not be precluded if in future any person having legal background is appointed to act as presenting officer.
Yes, Milord, my junior has submitted
Now,
this.
this order would be passed on the basis of anticipation.
No, Milord, my junior has, Milord, only 1 minute. I've understood your lordship's mind. My junior has made this submission on my instruction that you make this submission because he is not at fault. Number 1. Number 2, Milord, that tomorrow, if the tribunal order, Milord, if it's allowed to exist, and in view of the changed circumstances, it petitions becomes infructuous. But in the event the central government takes a decision which is contrary to the present one, then I shall have the right, because this is, Milord, virtually, this order shall remain in the court's record.
What applies at res judicata, which has been decided.
Right, here it has been decided.
What should have been decided? Here, what
They-
has been decided? you
This is
can't-
decided because the salutary rules do not permit engaging a practicing lawyer in a department.
Admittedly
7.
can be seen, only one line.
Which, Milord,
Admittedly be seen that the presenting officer is admittedly not a practicing lawyer, and hence he refused to entertain.
right.
Tribunal refused to interfere with.
So he omitted the last,
Last-
right.
If in the case any person having legal background, legal practitioner, legal advisor, such and such, as enumerated in that page 33, is appointed, door is open, you will again come.
No, since Milord, since my Lord Justice Chakraborty, when I left the court, Milord, has observed that, Milord, that, no, if I correctly remember, Milord, that all issues will be left open. So, Milord, that which includes this one, that in the event.
We have dictated.
We have already.
Because Lordship, now the present
We
presenting
said
officer is not from a legal background at
observed.
all.
Needless to observe
That he can.
that we have not decided the issue
Yes.
involved in the original application. We are saying that
Only,
it has
Milord,
become
whether-
infructuous.
Infructuous.
And
yes.
whether, Milord,
We are dismissing and we are adding a writer that we have not decided, that we have not gone into that issue.
yes, Milord, meaning thereby subject to correction, Milord, the order passed by the tribunal, it attained finality. because I carried this proceeding before your lordship. Because my lord, this order, my lord, remains unaffected by reason of this non-interference in view of the changed circumstances.
No, we are saying we have not decided the issue in what?
Lordship, the
Yes.
basis,
What
the
is the
foundation,
issue? That
Lordship,
whether legal practitioner will be allowed to be
Lordship,
appointed
the
or not.
found,
You have the fact
Which
that
my lord,
the
only
present-
one line, my lord, liberty is granted, my lord, in the event such situation occurs.
no, Lordship, my only submission is, Lordship, the foundation of
All
the
issues are
tribunal.
left open, my lord, kindly add this,
Lordship,
I shall,
the
my lord, stop.
Lordship,
All
the-
issues are left open.
Make up your mind, Mr. Bose.
All
We have
issues are left.
already dictated one order,
Lordship.
but since you have your junior wanted.
No, my lord, my junior is, my lord, the junior, my lord,
No, no,
whatever,
we
yes.
understand that.
Yes,
We were also juniors at one time.
Yes.
So he was a bit worried about what
yes,
is
yes,
happening.
yes. So, my lord, today, my lord, if this point, my lord, that is circular, because this was never considered.
Pretty clear that we have not gone into the
Merit,
issue that
sir.
in such circumstances the appointment was necessary or not.
আটা ধরে নিয়েছি আটা ধরে নিয়েছি So, my lord,
Lordship, Lordship, the
I was
We
only,
shall listen.
Lordship,
Government law officer.
The case is being prosecuted.
law.
GTI or a government
only, my lord,
advisor general. That evidently good and sufficient circumstances.
এ চলছে এই, এটা বন্ধ করুন হ্যাঁ, ওটা মক্কেলের হয়তো বলতে হবে না। মক্কেলের স্বার্থে তো বলতে হবে
আসো এখানে। We have said that we have not decided the issue as to whether the petitioner was entitled to the assistance of a legal practitioner when the presenting officer happened to be a legal expert.
Lordship, yes, that's fine.
Are to protect.
That's enough.
Now wait.
No, you are.
Speak,
Your junior again will say.
No, no, he will
Mr.
Yeah.
Lost the
That's
job.
fine.
Ask him, tell him
No,
he
he
has
will not
lost.
utter a single sentence.
No, you tell him that he has lost his job.
No,
No, no, it's fine. That's, I do.
Ashok. Yes, next.
Well, my lord, on behalf of Gola Mustafa, my lord, pray after vacation.
1 week after vacation.
Lord, I appeal for petition.
এইটাকে না ওই ফাইলটা আস্তে 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 বলি।
And I beg to represent the state lordship.
এটাকে একটু ওই যে আগের অর্ডারটা দিলাম না ওর ভেতরে এইটা রেখো। ও জয়ন্তকে যেটা দিলাম হ্যাঁ ফাইলটা একটু ঢুকিয়ে দেবেন ট্যাগ করে।
Lord, order included in this
Yes,
petition
we are going through that.
at page 190.
Yes, sir.
Lord, we are the private respondents in that matter. Here is we are the read petitions. We are not served copy. Now, my lord, if the order is, can you see, learned counsel for the applicant intends to
Then
withdraw the
who is
present.
for the read petitioner, Mr. Banerjee?
I am not, we are the read petitioner, we are the private respondents there.
No,
We are not
who are the original applicants?
original applicants.
Respondents
Respondent number 3 to.
Have you served?
Lord, we have sent the copy. We have sent the copy to them. Lord, it doesn't appear that they have received it, but they are avoiding the service. It means
They have got it.
no, they have not yet received it. Lord. I must say that they have not yet received it. They have-
We will say that the service is not complete.
Subsequent
Complete
development
and we
bullet
come
is-
back.
Lord, may I just say one thing, Lord, that just the problem is this, Lord, when the petition is defective and the court should not have passed further order, you go and make a representation and let it be decided, let it be done, and the already, Lord, the state has started the proceeding on the basis of this order. And we have come to learn about this order only on 24th September.
You
When-
were present on that date. Your
24th
client was present on the date of disposal.
No, we were not served there. We are not served there. Lord, if a petition is defective, want to withdraw, how the tribunal can file an order? Kindly see third paragraph. Accordingly, liberty is given to the applicant to withdraw the instant way with further liberty. Kindly, up to this, with a further liberty to file a fresh representation, including all the interested parties as per current land record and other documents, if any before the BSO and so. If such representation is filed, then it would be decided. How it can be done, madam?
Now, what is the present stage?
Milord. Say on the basis of this, Milord, order, proceeding has been commenced. We have been directed, we have been served a notice on 24th September. Last 24th September. Now then we have come to before the Lordship's court.
You appeared before BLR or Mr.
No. Only we have received a notice.
When is the date? When is the date?
Next
Before the
day.
BLR?
25th September was the date.
Achha, what
And by
happened?
default, my learned senior's friend client has won before the VLR also.
One before the BLR.
As because will refer.
Mr. Banerjee.
Yes, I have already informed my learned senior friend, Lordship. On 20, Lordship, the hearing notice, kindly, Lordship, Miller, at page 55, hearing notice.
So nothing remains, Mr. Banerjee.
50,
When
এক
the-
minute, sir.
We will record.
Page 55 is the hearing notice, kindly see.
The order is not sustainable.
Hello.
The order, yes, however, order has been acted upon.
Maybe, Milord, but this types of question is that this is not
Actually,
sustainable.
liberty was given,
What I am-
should have been given to
Milord,
five
what
eight
I-
original
Milord, just to your lordship, Milord, just if it is appealed to your my lordship, this types of thing is being done by the land tribunal. This is not correct thing.
But Mr. Banerjee, we also say sometimes that we are dismissing it as withdrawn on the prayer of the petitioner with liberty to him.
Dismissing is different thing.
That is
No,
what-
here is a defective petition. Here they want to withdraw. What your lordship does, that on merit your lordship is dismissing.
But the-
So, Lordship,
disposed of.
Lordship, on the
Final order.
Lordship, it was by default in favor of my
Mr.
learned
Banerjee,
senior's friend, right?
Want the order to be passed today or let it be on service? because you are enjoying a favorable order. Because if
It
we
may be
pass it,
disposed of, Lordship. It may be disposed of, Lordship. Nothing remains in this proceeding, Lordship.
Ashok,
May I respectfully hand over the order passed by the BLLR, Lordship?
May I just one thing?
Sir, it okay.
Just one. Well, Lordships, kindly record that this order has been handed over to Lordships today on record. Let the matter come up after vacation, Milord.
No, we are disposing it of.
No,
Mr.
Milord, this is the problem. I tell you, Milord, one of the thing is this order will remain. Na? This order is not sustainable in the eye of law. In future also.
We will record your argument, Mr. Banerjee. We will say that this order ought not to have been passed. However, we have been informed in view thereof, no further order is required to be passed in the
Order passed.
Ashok, affidavit of service as filed with report. Stop, Mr. Bondu, the present writ petition has been preferred. Challenging an order dated 13th March 2024 passed by the learned tribunal in the original application being OA 334 of 2014 bracket A LRTT. Mr. Bandopadhyay, learned senior advocate appearing for the writ petitioners, who were the respondents in the original application. Private respondents in the original application submits that after having granted liberty to the original applicants to withdraw the OA, as the same was suffering from incurable defects, the learned tribunal ought not to have granted any further liberty to the original applicants to approach the BLRO concerned. In the midst of hearing, Mr. Galib, learned advocate appearing for the respondents, however, submits that the order impugned has already been acted upon and the concerned BLRO has already passed an order which happens
Based on the
Previously, there was a hearing notice, my lord. That is at page 55.
In course of hearing, Mr. Galib,
the order impugned has already been based on the
and the concerned BLRO has already passed an order.
Not challenge.
If they challenge, you say that I will raise a point of interest.
I think you should not require to.
All right. All right.
Raise judicata on the plea of raise judicata. That earlier it was recorded.
Finally published
Acha,
record of
the
rights.
petitioner-
Section 50.
Cannot be disturbed.
petitioner is, however, directed to intimate this order to the private respondents immediately. I don't know whether they have anything else to say. They have.
How can they, my lord? Because they are doing mischief without, my lord, this finally published record of rights. They want to disturb.
There is no service completed. Na?
We shall serve a copy to the other side. No, because this.
My lord, may I say, my lord?
It was, Miller, prior to passing this order, there was a hearing notice given. Kindly see page 55.
We are not on that. We are wondering. It's a read proceeding. No, no.
Service has not been not effective. Not effective. Service has not been effective.
In view of this fact, we are not. There is no use of.
Rule 26 pair is there. Service dispensary.
Disposal of the writ petition in absence of them.
এরকম কোনো সিমিলার অ্যাপ্লিকেশন যদি পরে হয় বিফোর এনি ল্যান্ড অথরিটি,
এরকম হয় না
এই অর্ডারটাতে দে উইল নট বি অ্যাফেক্টেড প্রেজুডিস। তাহলে কি
না ওসব বলা যায় না হয় না
কিছু বলে যাচ্ছে।
When did you send it? Copy the. Maybe around সেটা তো আমরা বলে দিচ্ছি। আর কি আছে?
to do it in all over India in all courts.
Yes,
Just
yes.
internet. Give the-
Thank you. Yes, Daku, next. কত নম্বর? তাহলে 1 PM টা ডাকো।
So in this matter, I am appealing from the respondent number 8.
Where is Mr. Basu? Rajushree Basu? What happened? The hearing took place.
Milord, yes, my lord. Both of us present there, my lord. But no order had been passed.
No order has yet been passed. Then did you appear?
Yes.
Then when is the next date fixed?
No date was fixed.
So did you have a talk with Mr. Basu?
Yeah.
But Lordship, it is the parallel proceeding. Lordship, parallel proceeding.
Where is Mr. Basu?
My lord, kindly take the matter tomorrow, my lord, fixed. Tomorrow, my lord, kindly. We engage another court, my lord. Rajesh Basu.
Engaged in another.
আরে অর্ডারের কপি কিছু এসছে আপনার কাছে বলুন না জজ সাহেব ওই
Nothing.
Yes, Lord, no order had been passed.
Fine,
Lord.
fine.
আরে ওইটুকুনি জজ সাহেব জানছে বলুন এই তো এসে গেছে।
Yes.
My lord, on the last occasion, hearing was given. My lord, no decision, my lord, is communicated because that hearing was given on 4th and 5th onwards, there is a holiday in the government offices. It will reopen on 21st of October. So any steps that might have been contemplated by the concerned authority or the decision, it will be communicated upon the appellant hearing 21st October onwards, because before that, that is not possible. The offices will reopen on 21st. Like that.
No, Mr. Basu,
My lord.
do you know that any order has been passed or it was adjourned?
No, my lord, till now, my lord, the hearing is concluded, but order has not been communicated. My lord, the authority, they have not even informed me that this order has to be passed or anything else. They are in contemplation. They will take into consideration the submissions made by my learned friend's client and my lord, the records.
Then
Yes,
you have
nothing
already
remains
got
in the
the
appeal,
protection.
my lord.
My lord,
You have already got the protection.
my lord, till 7th. Protection is till 7, my lord. Kindly have a look into the order, my lord.
Yes, my lord, till today there is a protection. But my lord, what my learned friend's client wants.
Extended, my lord. In the meantime,
Why?
if they
In appeal, they have not got any order.
Who are you?
Lordship, I respond number 8.
Well, he was the writ petitioner, my lord.
Yes, what do you want to say?
So, Lordship, this is the parallel proceeding because on the basis of
You
the
are
90
also opposing the proceeding because you raised the issue and you are also now in problem.
No, I have, Lordship, I have, there is 4 enclosure.
My lord,
Given,
করে নে, আমি তো 3 মিনিট বলবো।
কালকে কি হবে? কালকে না। তো আমাকে পাবলিক ল্যান্ড আছে কি দেখাবি দেখা। আবার প্রতিজ্ঞা মানে যে সিঙ্গেল বেঞ্চ জাজমেন্ট নিয়ে চলে
এরকম করো না তো দেখো না তো কিছু।
আমরা তোকে আমি দেখাচ্ছি মজা। দি অ্যাপেল
তোমাকে দেবো কবে?
না ঠিক আছে ঠিক আছে। Let me see. The appellant is.
My lord, may I be given audience for 2 minutes, my lord?
Yes, my lord, you will hear.
My lord,
Is in the habit of addressing distinguished gatherings and all.
My lord, my lord. Appellant is asking for injunction where they have no rightful interest.
my basic
They have
point,
not responded.
basic
Produce
point
any
in this
documents
matter
in
is, my lord,
respect to the government land.
Basic point.
yes, my lord, I have
Come to page, we will show you that your client is come to, you have not seen, this is the problem. Kindly come to
No
page
documents.
103.
100
Please come to 103.
yes, my lord.
Read from hard all present. Your client do not tell you all the facts. Read that line. Hard all present. Loudly you read.
Hard all present.
Read.
Yes. Hard all present, consulted the reports and other related papers. All the encroachers are present. The SDO, Rai Dighi,
Subdivision submit.
Submits that the land is in question belongs to the collector, South 24 Parganas. All the alleged encroachers, including the writ petitioner, Sachidananda Das, were given opportunity of hearing, but they failed to produce any valid documents in support of their legal right.
Given
Over this is
over the
illegal.
suit.
Over the suit, government land. Government land. They all admitted that they are all in occupation
Of
of
the-
the government land in question, and they will vacate the government land in question as and when the government requires the same in future.
Then Mr. Dolopati, what remains?
Here my point is here.
What point?
My lord, my basic point is
What point you admitted? What point you will argue?
point of law, my lord. before
What
the-
are point of law?
Yes, my lord. Yes, kindly allow me 1 minute.
Yes, we are allowing you.
My lord, order had been passed by the learned single judge.
We are not on that.
Yes.
You said that yes, I am an encroacher.
No.
I will vacate.
Lord, this is their recording.
They are.
This is their recording. My lord,
This
even
is their recording.
Yes.
Acha, show the ground in your appeal.
Yes.
এই হচ্ছে problem. Show the ground in
Yes,
the
Lord,
appeal
I am
that
not
there was a
encroacher.
wrong recording in the order. Show us. Your appeal memo you have annexed. Page
Yes.
92 onwards.
95. Lord, from the memo I am
From the
pressing, Lord,
95, show us one ground that it has been erroneously recorded. I did not make any submission. One ground. And we will quash the proceeding. You show us one line.
my lord,
That your
ground number
clients-
7. Appellant issued a notice upon asking
number?
him to appear
7, my lord.
7.
from ground number 7.
Huh? Huh?
My lord, my
Where Mr. Dolopati, that there was a wrong record.
The respondent number 8 has suppressed.
Yes.
Who was respondent number 8?
The appellants prefer the statutory appeal. Forget about it. For that, the proceedings
Opodol
initiated.
Boiragi, something suppressed.
No, my lord, what is my humble submission is,
Your humble submission we have answered.
my lord, in my appeal, I told I am not at all encroacher.
Mr. Dolopati, we are asking you a simple question. Your client has admitted that he is an encroacher and he will vacate when the government asks him.
But my lord,
Part will not arise. Show the ground that your argument is that that is a wrong record. I did not say that.
Lord,
Please show the ground.
not just
show the
like this
ground.
language, but my lord, in the
Mr.
appeal, I
Dolopati,
told
don't
I am not the encroacher at all. In the appeal, I told this. I am not encroacher.
So you have no other choice because you have already admitted.
No. My lord, why, my lord, kindly
My
allow
lord,
me
subject to correction, I am interrupting with your lordship's intelligence. Your lordship is inviting my learned friend to show a ground from the appeal preferred before the learned district magistrate. My learned friend is reading the memo of appeal preferred before this honorable court from not here. You have to, my lord.
No,
No.
My lord. My lord.
No, come to state.
Even my lord, the appeal.
Yes, my lord, the memo of appeal preferred before the
Yes,
district
yeah, I am
magistrate.
He already caught on the wrong foot.
My lord,
So
95,
thinking what he will
96,
say.
97.
Caught on the wrong foot.
No, my lord, I have 2 points only. In the appeal, I told that I am not encroachers, number 1. Number 2, very vital point, my lord, before the division bench, how the authority exercise the power under this act. The authority have no right to exercise this act. My lord, kindly have a look into section 3. Cannot.
Why we will go into that?
My lord, the section says, the act says, if the owner of the public land requisite
Mr. Basu, tell
or
us,
made requisition.
My lord.
tell us one thing. This you have arrived at a finding as regards encroachment.
My lord. That is the
You
finding, my-
specified the measurement.
My lord.
So on what basis you did so?
My lord, report, my lord, that your lordship will find from the order of
Please
the.
listen to my question.
My lord.
Please listen. Page 102, the 24th June 24 order. You have said passed an order and decision to take decision in accordance. Sachidananda has encroached 15 feet such and such. Private resident Shoshodar has encroached such and such. Other 3% Solil encroached 625. Where from did you make this demarcation?
PLO has measured this. PLO has measured it.
Where
And
is
then
that
sent.
report?
My lord.
That report,
And I have not been given any opportunity.
You can report of the BLRO. Yes, he is not annexed.
Here,
Annexed.
plot number.
Now, my lord,
ওই তিনটা জিনিস দেখেন
এটা কিন্তু কি এটা 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 কোথায় পেলেন?
প্রথম ক্লিক করছি এখন রিপোর্টটা জমা তিনটে
ঠিক আছে, এটা আপনার আগের রিটে ছিল। এক মিনিট রাখুন, এটা কপি করে নিয়ে আসতে হবে। যাই হোক, আমার বক্তব্যটা অন্য। দিল তো ইন্টারভিউ
দাঁড়াও, তোমাদের সরকারটা দুর্নীতি, ওই আইন অ্যাপ্লাই করতে পড়ে আসবে পড়া।
আর বেশি কথা বলো না, এখন আইনটা পরে দেখা হবে।
আইন লড়াই।
just a moment, Mr. Vasu.
My lord, আপনি রিপোর্টটা আমার সাথে শেয়ার করবেন। ওই রিপোর্টটা আমার সাথে শেয়ার করবেন।
আচ্ছা, এরকম
মাই লর্ড,
ওই যে till 7th appeared on 7th till 8th November 2020. Worship station till 8th.
My lord, I
will
understand.
appear on 7th.
My
Bad key judgment.
For the appellant, my lord, led by Mr. Kobir, my lord, he's appearing.
Lordship, I am appearing online in this matter. As I am suffering from jaundice, I couldn't be present physically, Your Lordship.
Jaundice. আগের দিনই দিয়ে দিচ্ছি।
দেখে নিয়েছি
বিলিরুবিন 7 বলবো।
কি করেছো?
আমার বাবাকে বলেছে ল্যাপটপ আপনি শুনে দেখেন।
মানে ওর প্রকৃতি লাস্ট প্যারাটা করেছে তো সেটা এখানে discussed your arguments as advanced. We have discussed the proposition of law. We have dismissed the appeal.
Grateful now.
Sorry, with a better this.
Obliged.
May I take one indulgence?
Yes.
May I take one indulgence? Item number 19 and 20. 19 and 20. Today it will not be taken up. Tomorrow, I have some difficulty. I am for the appellant. 19 and 20. Item
12 noon matter, that is another matter.
19 and 20. Two appeals are there.
Order fixed chilo shede.
I made appear any day after vacation.
Who is the other side?
Other side.
Taken up tomorrow, my lord. Let it be taken up tomorrow.
Tomorrow,
Because we the writ petitioners, my lord. Because we the writ petitioners out of the 60 members of the writ petitioners group. My lord, already.
The cause of action arose.
My lord, the
12 noon matter.
case was pending since 2011 before the tribunal.
Well, that is a different issue, my lord. I have prepared an appeal.
We are suffering. We are suffering, my lord. My lord,
but tomorrow is the last day, my lord. I have some difficulty. If today could have been taken up, I am ready with the matter, my lord. I told my learned friend.
Yes.
I was ready today, my lord. Mr. Dotto is also ready in this matter.
Any day, my lord, supplementary list kindly fix.
Any day.
Otherwise, we are the most worst sufferer.
আর ওই যেটা আছে
74 12 noon matter.
it will come on the reopening date.
On the reopening day.
Who is your other side?
Other side is there.
1920 টা কবে হলো?
এটা ডেট দেখছি 74 item number 74.
Any
Item number is
74.
And date fix.
Date fixed. 4 orders. Sunset heading 4 orders.
আমি বলছি date fix করে দাও।
আচ্ছা we have item number as we have heard the matter extensively, the same shall be treated as heard in part.
Supplementary list.
One week after that.
My lord, any day my calculation. Supplementary list kindly, my lord. Otherwise, my lord, we are the worst sufferers. We are not getting any benefit. my lord.
What date you want, sir? It will appear in the list. Come and tell us. We will reach. It is the fourth matter in
It
the
can be done
assignment.
here and now, my lord, any day kindly, my lord.
Chalo.
My lord, this bench will not sit. দুটোর পর বসবে না
এই 19 আর 20 1 week after week.
দুটোর পর বসবে না নাকি
74 টা 14th হলো না
But I'm being led by Mr. Saraj. But I'm being led by Mr.
May I please, Lordships, I appear for the petitioner, Atmadi. Lordships were pleased to issue notice on the last occasion and posted the matter on 30th September, Lordships. And on 30th September, Lordships had recorded the undertaking of the government for the admissions to be made by the state government or the recruitments. Now, Lordships would be considering today the university admission status, my lords. In this regard, I would like to place twofold submission, my lords. Two things Lordships have done through the 22nd May 2024 judgment, namely the quota which was increased from 7% to 17% has been reduced back to 7%.
Mr.
So
Puttaraj,
now all the yes, madam.
why we wanted to, because we have expressed our mind on the last occasion.
Yes, madam.
That is reflected in our order, and we have also called for an affidavit from the government.
Yes, madam.
As the universities also, we have already expressed our mind. Now, if
I'm grateful.
appointed, and if it is ultimately found that it is derogatory to our judgment, naturally the consequences will follow.
Yes.
And the Supreme Court has also not heard the matter. So, subject to what everybody says and what my learned brother says, we want to fix a date after the vacation, a specific date. In the meantime, we'll call upon all the parties to complete their evidence so that
Very
we
well,
can
my lord.
finally decide the matter.
Very well, my lords. But in the interregnum, my lords,
My lord, in item number 2, my lord.
Yeah, just let it be finished. So this is, you are in item number 1.
one, my lords.
So, yes,
In the interregnum, Lordships would kindly.
Justified. But so far the affidavit is concerned, as soon as I got an information that an order has been passed by your lordship, he has not, although your post was advertised, he stopped everything, and I've given an undertaking that will not proceed with the matter until the matter is either decided by the Supreme Court or decided by the Supreme Court.
Where is that paragraph here said?
Within the affidavit. Lord, we haven't received any copy of the affidavit.
Please serve a copy, Mr. Mukherjee.
You affirmed it on 4th, Mr. Mukherjee. Why didn't you give it on 5th? 5th we are open.
Now, kindly see page 4. The respondent says that one recruitment notification has been brought up by RDSN and due to the ignorance of said order, but no admit card has been issued. So any application undersigned also in the light of the judgment that no further steps will be taken in regard to the said recruitment notification. Future all procedures whether have been stopped. We have given an undertaking before the lordship that will not proceed with the notification.
Are you initiating any other proceeding?
But at least
Government is taking any further steps?
Subject to availability of the IA or for the hearing, because we have filed an application in connection with the IA for that is that nothing will not proceed with the matter.
Yes.
We are only asking you, Mr. Mukherjee, what my brother was asking. Are you planning any recruitment to include in this any recruitment in the state to include those classes which we have struck down? We want more from you.
We have so far as the judgment declared by your lordships declares in section 5A to be ultramarine. But on the basis of that, list 3 has been practically nothing.
So
100%.
record that statement of yours that the state is not going to violate our judgment
Right.
so far as any recruitment process until the
It
decision of the
is
Supreme
Supreme
Court
Court.
in this regard.
Yes.
Can we record
Yes,
that?
yes.
Very
And so far admission is concerned, but so far admission is concerned, kindly consider.
admissions.
Admissions, what just I'm giving. Article.
One by one. So item one, sir, you've heard the
Yes, my lords.
heard the state.
Yes, my lords. That undertaking will be adequate, my lords.
Record that in our order.
Yes, my lords.
That ends your the first matter. We'll call for affidavits in the state, and whatever will be decided by the Supreme Court thereafter. The first
Very
matter
well.
by that.
There are two issues in the first matter, admissions and recruitment. My lords, recruitment gets covered by this.
Oh, university.
Undertaking.
It's covered. Admissions are also mentioned in the first matter.
First
too.
matter. Yes.
The second matter covers admissions exclusively.
We covered both, my lords, so it's overlapping.
In the
Initially, we
part-
filed university
that is the
notifications are under challenge.
exercising power under section 15(4)(5).
Notifications.
Notification, no, not Act, Statute of 2013 Act.
Challenge.
They have not challenged.
In the second one, there is a challenge. Now, in the first one, we are only confining ourselves to recruitment for the time being.
Yeah.
We will say that in respect of the this one, the admissions, that will be covered under this second matter. All right, let us segregate the two. আচ্ছা, আমরা ওই comprehensive না? Second university matter
সে তো আমি বলতে পারবো না।
comprehensive challenging action. তো এইটা ইস্যুটা আমরা বলে তো হ্যাঁ আমরা শুধু বলে তো so far as admissions are concerned that will be covered by the WP order to be passed. Yes, now come to the second.
My lord, first I sincerely apologize, my lord. My senior couldn't be there, Mr. Guru Krishna Kumar, learned advocate, due to personal difficulty, my lord. My lord, in the last order dated 30th September 2024, my lord kindly sees a prima facie case has been made out in the second writ petition, my lord.
This is 387. 387.
387. 430, my lord.
এইটা তোমার first.
order দিয়ে দাও।
My lord, kindly comes to paragraph 6 onwards.
Just
My lord,
আছে তো এর মধ্যে আছে মেনশন আছে তো হ্যাঁ ঠিক আছে শুধু এই অর্ডারটা 18 and university issue admissions dealt with in this one it will be covered by that.
You know.
Mr. Mukherjee, learned additional government leader, has filed an affidavit, a report in the form of affidavit, affirmed by one Subodhi Bhattacharya. Subodhi Bhattacharya. Response number 10. Who is he?
He is the child development officer under whose notification was issued.
The CDPO. Who issued the notice of recruit.
Your DM has not affirmed.
No, DM has not been implemented as a party respondent.
yes, DM is a party.
No. But, can you see?
Is there.
No, but notification has been issued by the.
Number 4, my lord.
Just give me 1 second.
In the second part of paragraph 2, at page 4 of the report, it has been stated as follows, set out.
Set out dispose.
9 and 10.
Mr. Mukherjee
What else?
has further undertaken before the court on instructions that there shall be no recruitment in the state in respect of the classes struck down by this court's judgment dated 22nd May 2024, passed in WPA bracket P 60 of 2011. The above. Now it is further submitted that recruitment processes shall abide by. Now that that's it. Full stop. Correct. Insofar as the admissions to universities are concerned, this court is of the view that since a comprehensive PIL being WP number 30,
WPA bracket P 430 of 2020. Has been
so far.
This court is of the view that since a comprehensive
WPL has been filed and is listed before us today. All matters regarding admission shall be covered under orders passed in the said WPA number,
in the said WPA bracket P 430 of 20/2020. দেখে করো আর কি।
the parties filed affidavits in opposition by 2 weeks after the vacation.
Yes.
2 weeks after the puja vacation, reply if any within a period of 1 week thereafter. Yes.
For ours also?
Yes. No.
We are coming to your matter.
Yes.
We are only dictating reply when we week thereafter. Liberty to mention or not, we'll fix the date. What do you say?
Yes,
We can fix the date.
একটা দেখো তো 3 সপ্তাহ পরে একটা date।
কিন্তু আমি নেই 2 সপ্তাহ আমি নেই আমি করতে
কোথায় যাচ্ছ?
পড়লে
ছাড়লে না যাবে না।
admission.
No, we are reopening on 4th.
4th November.
2 weeks takes us to 18 and 1 week thereafter takes us to 25th.
Yes, my lord.
So we can fix it on 27th November. Is that all right with everybody?
27th.
Yes, ma'am.
27th is
Yes,
a
my lord.
Wednesday।
Wednesday.
2 p.m.
Yes, ma'am.
কিছু নেই তো 27th at
এটা সরিয়ে না আমি 4 তারিখ থেকে
immediately প্রচন্ড প্রেশার টিকিট দিতে দেওয়া যাবে। এই শোনো অনুপম, এইটা দেখে নিও বাবা, কোট আনকোট এইটা যাবে।
দিয়ে দাও চলো
পরেরটা বাবা উঠো না একটু।
My lord, I'm appearing on behalf of the petitioner. My lord, in this matter, my lord, a prima facie case has been made out, my lord. Therefore, my lord, kindly hear the state list which has been struck down. The 2 notifications which has been struck down are followed by the higher education department by, my lord, maybe it is statute by simple reference because, my lord, 2013 Act relies on 2C of 1993 Act, which prescribes the lists for appointment into the posts. So therefore, my lord, since those 2 notifications which we have annexed are already struck down, which were in exercise of powers under section 2C, my lord, kindly takes page 23
এই আমার ফাইলটা দাও।
of the writ petition.
এটা সাহেবের ফাইল।
Page 23 of the,
our earlier order, which paragraph you are
my lord,
saying?
my lord has given a detailed view from 6, my lord, kindly comes. This appears to be ex facie illegal as Section 2H and Section 2I of the Act of 2013 require recommendation of the Commission constituted under the West Bengal Commission on Backward Classes Act 1993. The only inference possible is that state has recommended the same classes of OBC, OBC-A and OBC-B from the 2012 Act that have been struck down by this court in its judgment dated 22nd May 2024. There is a prima facie case made out by the petitioner. Therefore, my lord, we are pressing for our interim orders, my lord. My lord, we are pressing prayer F, stay of the operation of those sections.
But that I am opposing, my lord.
No, that we have expressed an opinion, there's a prima facie case.
My lord, I will please.
So we have also expressed that the university would be liable to pay compensation in the event it goes against them. So today, these observations we have already made. Now, if a particular person, student is allowed to prosecute his classes, that will be at their risk and peril. That will be at their risk and peril. Last paragraph of the order.
Yes, my lord, but my lord, the entire state.
Because this will not be having effect only pertaining to a particular matter. This is pan the state of West Bengal. Now, we don't have the data also, apart from these two universities, which further universities are also proceeding in this fashion.
My lord.
So we have specifically incorporated a clause to that effect. Today, if any person is admitted and if that admission goes in terms of our order, the university would be liable to pay this compensation to them because they are not parties before us.
Yes, my lord. My lord, I bow
It's
down.
considered about the pan-state situation.
My lord, my lord, if sees the statute, 2013 statute is by place, my lord.
We have made our point
Directly refers to the 1993 Act lists, my lord.
What is referred here?
Yes, my lord. And those are struck down. Those specific two notifications has been struck down, categorizing A and B.
Yes.
So, my lord, therefore, there cannot be today any categorization of A and B in the state of
prima facie, madam. That is why we said prima facie we are of this.
My lord. My lord, now that's why we are praying for the stay of the operation of this order, my lord. Operation of those provisions, my lord, because it directly refers to the struck down notifications.
Can you show me one instance where a provision of a statute has been stayed pending hearing?
Have the writ petition.
It can be struck down.
Not a single
Can't
instance.
be stayed. A provision of a statute. You will not find a judgment in this country till now. At an ad interim stage or interim stage.
That is why Mr. Guru Kumar is not.
There are three issues that you will have to bear. Three issues. One, this is for the benefit of all parties so that you will address court on this. Has the backward classes department of the state issued any separate notifications under 15.4? First. Two, the Indra Sani judgment as also our judgment, the 22nd May 24, clearly indicates, I'll give you the para numbers also, that 16.4 subsumes 15.4. Please look at the notifications issued under the 2012 Act. Each of the notifications and recommendations by the commissions, please make a note of these things. Each of the recommendation of the commission at the end says that this class is socially and economically backward, which clearly brings it under the purview of 15.4. Each of the recommendations of the commission. We have taken it upon ourselves to scan the website of the backward classes department. We have not found any notification listed there under 15.4. It could be presumed that you were just following the notifications under 16.4.
So please ascertain, that's why we want an affidavit from you, whether any separate notification is issued under 15.4 or not. And the fact that we've referred to that other judgment, once it is struck down under one law, under one, let's say, statute, it appears to us prima facie that it is a carbon copy borrowed from there. But we can't express that opinion at an ad interim stage. We don't want to. For which reason, madam, we want them to file an affidavit.
Let them come with the affidavit saying
They
that
are put on sufficient notice of the consequences that will follow if it is struck down. It is not as if the OBCs will not get admissions. No. The 7% that was there before these notifications, 2010 notification, you had
66 classes, my lord.
And but apart from that, central government also after the
central government, what it is doing, what we are concerned with the state of West Bengal, sir. We are concerned with our state. Please bear this in mind, Mr. Mukherjee, you are running a risk. There will be financial outgo of costs and penalties.
But after 2010, which has been said by your lordship, that official will come.
After 2010,
whoever the class 60 odd classes which were there before 2010,
we are not affected.
The judgment does not address that.
Yes.
And we have
admit them under OBC.
Yes.
We have incorporated that in specific term. Prior thereto, not affected.
But this amendment, legislation of 2013 exercise power under Article 15.5, not
That is
16.4.
what my lord is saying, that it has not been brought to our notice as to whether there is any other independent notification to the effect which Mr. Mojumdar on the last occasion said that I shall produce everything. So far as our study goes, there is no such, and he is laughing today. So he has failed, and he will get that 5
We can't
lakhs.
get it, but we want an affidavit from you. And we have already put you on notice.
What would be the effect of referring a notification in a different state later?
Absolutely, Mr. You know the answer yourself. Your question begs the answer. I mean, it is already struck down because of inadequate. No. Inadequate survey. Improper survey.
One is non-consultation, inadequate survey.
And when you say there is no separate notification, it is presumed that the same notification therefore were applied. Which notifications have been struck down by us?
You got any separate notification?
From your website, we could not find any.
The university has now closed, but I tried to get one about 2015 notification, but that's only 300 procedural ask, not the list.
So you better watch it, you will be forking out money. So you do what you think best.
Do what you
On this issue, may I just assist, my lords?
We are concerned about the students. Irrespective
May I
of
just
whatever it is, we are only being slightly liberal here as of now, that too. Only in the interest of education of students. I mean, good, bad, indifferent, if somebody is educated, it will only inure to the benefit of society. This is the only principle that's bearing in mind. But if tomorrow we find out, after affidavits, that these persons were not entitled to admission, it will be presumed that persons who deserved admission did not get it. That will be a worse consequence as opposed to, because if this quota was not there, they would have been left to general quota.
There are hardly any takers for the general course nowadays.
The reserved, whichever course it is, let's say they are very chosen, very highly demanded, course highly in demand. And you have reserved seats for OBC A and OBC B, which means those seats are not going to general candidates. And they will be deprived.
So it will have a dangerous implication. Society at large.
Both ways we will wait. The wrong person getting admission and getting educated vis-a-vis the right person who is entitled to education. The course, not getting the, so it both ways it hits you. So you think what best you do?
What about the status before the Supreme Court? Is it, is there any possibility?
No, no, my lord, from today, it's a holiday, vacation has started in Supreme Court.
When is it reopening?
My lord, possibly on 14th.
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 So has there been any endeavor for early hearing?
But a mention has been made.
It was
Mentioning made.
But how will that?
Running in the list on Tuesday, Wednesday, and Thursday.
Pardon?
In Supreme Court, the matter is running in the regular list of Tuesday, Wednesday, and Thursday. Regularly on the hearing days. But the matter is not reaching.
So they are saying that they have mentioned.
They have mentioned and it is there in the list. Now it is vacation, but after vacation from 14th, it will again be there in the list on Tuesday, Wednesday, and Thursday. Because
So
Monday and Friday is fresh admission.
If it goes either of the way,
My lord,
matters will be.
in the website now, as of now, it is showing tentatively on 15th of October.
আমরা কবে রাখলাম?
Likely to be listed on 15th of.
No, no, এটা
আছে কি?
be acting.
My lord, one prayer only we have, my lord. My lord, this order may be communicated to all universities, my lord, by the Higher Education Department, my lord. The order of interim order that universities.
The
Much obliged to your lordship.
Good stuff. In the first line of paragraph 10, the order dated 30th September 2024. The expression, the state appears to acting clearly contumacious,
Quote unquote.
shall stand corrected to read as the state appears to be acting contumaciously.
তাহলে ওইটাতে আগের সেন্টেন্স আরম্ভ করতে কি লিখেছে পড়ো দেখো ফার্স্ট লাইন হ্যাঁ আপনার সব পার্ট
Shall stand corrected to
yes
that's the order remains.
Other portions of the order shall remain
Your name, madam?
Dipjani Rai. Dipjani Rai.
Ms. Devjani Rai, direct counsel. The petitioner has sought a stay of notification of section
My lord, 2I31C.
31C.
31D.
31D.
Of the West Bengal State Higher Education Institute Reservation. My lord, prayer F, my lord.
Prayer
F.
Sought for an order of interim stay in terms of prayer F,
which answers
of the writ petition. Prayer F is set out as follows. This court is of the view that
শোনার আগে তুই স্ট্যাটিউট স্টে কোথায় থাকতে হতো
অ্যাডমিশন তো বন্ধ করে দে
provisions of statute are seldom, SELDON, seldom stayed pending consideration of their constitutional validity. Very good. The issue shall be considered along with the other prayers after exchange of affidavits. Now, this court is of the view that is the same. We feel that the issue could be addressed in a comprehensive manner after receiving affidavits from the respondents. Sufficient indication and protection. Sufficient indication of consequences have already been made in this court's order dated 30th September 20. The state shall communicate a copy of this order as corrected of the order dated 30th September 2024 and the order passed today to all universities in the state. Forthwith. Let affidavit in opposition be filed by the respondents within 2 weeks after the vacation. Reply within a week thereafter. List this matter. Same day
That's one thing. But some educational institutions, just like technical schools, which is called certain educational, just they are under that AITC. They are also educational institutions.
AICTE.
Yeah. All India Council of Technical Educations. LCM.
That's only giving approval.
No. AICTE notified the vacancy on the basis of the test conducted by the.
No, you will communicate to all.
Instead of all educational institutions.
Universities are
But
there
kindly, all educational institutions.
in the medical department. I'm in the fishery department. So ministries are different. So it may be communicated to all the departments of the state.
All the universities specifically.
But they are not the university. They are under the All India Council of Technical Education.
All universities and educational institutions of the state.
They are regulatory authority, my lord. This Medical Council of India, AICTE.
AICTE has approved that.
Approved that.
Yeah.
But actual recruitment is conducted by the universities.
Yes.
The courses, the mode of instruction, the infrastructure, all these things are approved by the AICTE.
Yes.
But they are not involved in the actual recruitment process, in the admission process.
No. They only recognize by the number of students.
We have said about section 2H and 2I.
Yes.
That is pertaining to a state legislation. And in the view of that, we have said, as we have taken a prima facie view, you communicate to all universities in the state of West Bengal.
And educational institutions as also the recommending bodies. Recommending bodies because the tests are conducted by them.
Line all insurance. Now, the state is directed the sanction.
Act of correction.
Copy of this order, copy of the order dated.
Copy of the order dated and a copy of
All cities and institutions as also the recommending bodies.
in the state.
Are you indicating that the recruitment is a process like something like the NEET or something like that? Is it conducted by an independent body?
No,
the examination is conducted by the National Commission. Then the counseling takes through the West Bengal Commission. And the West Bengal.
No.
Stakeholders and every stakeholder involved in the admission process.
But admission, so far advertisement is made prior to the delivery of the judgment.
goes it?
We have asked you to communicate.
You communicate,
You
you do.
communicate.
Thereafter, they will.
Thereafter, we are saying
Because
after
joint interest of exemption was held prior to the delivery of judgment.
So very good. You argue that at the time, let them exchange their affidavits and you communicate this. You are the state. You communicate, let everybody know that what is the intent of the court.
Your Lordship, can you direct the petitioner to publish an notification under Order 1 Rule 8 so that the
First of all, you are acting contrary to your judgment. And now you are saying that responsibility be given to them.
No. So that because a large number of
That
people
we will consider. We are aware of that issue. We will consider.
If any
Because the
student wants to join in, let him make an application or student body. We'll consider that.
But your lordship is not staying admission.
No. They'll face the consequences.
Well, at least, my lord, your lordships record that your lordships. Your lordships, I
We have already on the
I have read that your lordships is not that they're taking admission with the, my lord.
Why should we aid them? Let them do, let them face the consequence.
No, we have said,
come to their aid.
We have said, we have expressed our prima facie view in the earlier order.
And that I know, your lordship. But that's your lordships to the extent normally.
And we cannot provide, as Ms. Roy said, we dealt with that argument that this is the statute which is to be struck down. Interim stage.
My lord, I got that point. I got that point. But by the judgment of your lordships, the very definition clause goes.
Exactly, we have recorded that.
Very definition clause goes. Therefore, nothing to be struck down virtually.
Daniel, the thing is, we want to know on affidavit as to whether there is a separate notification issued under 15(4) and 5 by the state.
My lord, I just only, my lord, my lord, what's the apprehension is that, my lord, the petitioner suffered for last 12 years. This is a writ petition of 2010, 2012. We could, because we didn't get an interim at the initial stage, for any reason whatsoever, we succeeded. But in the meantime, whosoever got benefit illegally, they are now, my lord, their interest.
That cannot happen today, because we have said that 5 lakhs compensation will be carved upon the university. We have said that, and even after that, they do something, it will be at their risk and peril, Mr. Sannal.
And in so far as there is a difference between recruitment and admission. Recruitment will have far-reaching consequences on the state.
Admission also.
That's why I said passed a separate order there.
I have just
and we have recorded Mr. Mukherjee's undertaking that there won't be recruitment in the state based on the, of the classes stuck down. Leave that aside. Now admissions, as we were indicating, there are wrong students who may get admission, disentitled students, and a right student, entitled student, will be deprived. Now, that is much lesser of a situation compared to a recruitment process. Now, socially, the consequences may be wide.
Suppose, my lord, I am entitled to get an admission in MBBS course, but I don't get it because of
because the quotas.
Quotas. Then your losses. My right is forfeited forever.
Mr. Sanyal, it is the candidate who should come forward.
No, my lord, my lord, put normally your lordships sometimes gives a clause that everybody must be aware that they are taking admission. Apart
Yes, we have said so. State will communicate these.
But
every university and everyone.
But so far as the NEET is concerned, notification was issued prior to the delivery of the judgment.
Doesn't matter.
Prior to the delivery.
The examination may have been held prior to the judgment.
Yes.
But the admission is happening after the judgment.
Yes, certainly.
Meaningless.
The consequences will definitely be covered.
by judgment এটা চলে যাচ্ছে আমার মনে হচ্ছে না বা ইমপ্লিকেশন চলে যাচ্ছে না ওটা অন্য সেই জন্যই
আমার
my lord,
কি করেছেন
সব একখানে মাখিয়ে
my lord, may I only trouble you with the last order? There is a typographical error, my lord. My lord, internal page 2, my lord, on the last order, WPO, it should go as WPO 60 of 2011. The order was passed.
We ordered. In which matter?
My lord, 430. second line, WPAP.
Second matter is ওই যেখানে লিখেছো প্রথম প্যারাগ্রাফ second page.
My lord, second page, internal page 2, at the
Which paragraph?
at the top, my lord.
What
Paragraphটা বলো।
Paragraph
Because it's a
number 2.
continuation of paragraph T.
P60.
No, no, that is WPO. It was in the original side, my lord.
WPO. It should be
WPO 60 of 2011.
P will be there.
No, P won't be there. In that, there is no P.
ওই correction করবো তারপরে আরেকটা in the third line of the continuation of paragraph 2 at page 2. In the third line at page 2, which is a continuation of paragraph 2 of the order dated of the said order dated 30th September 2024, the expression WPA in bracket P60 of 2011 is scanned corrected to read as WPO 60 of 2011.
কত 27 নম্বর but at 2 p.m. 27 number.
No, no, we will start from morning. Please, I will catch hold of my brother and
Thank you very much.
Got it? Give it to me, this. শোনো, এটার একটা ভালো 27
হচ্ছেটা কি নট টু টেন?
Yes.
My lord, item number 65, my lord, I am for the petitioner, my lord.
$65.
Yes, my lord. Sujan Kumar Seth.
The hearing matter is your other side.
My lord, I have to check, my lord.
Anybody in the motions?
My lord, item number, my lord, 26, I appear for the, my lord, Southeastern Railways.
26.
My lord. On the last occasion, when the matter was called, my lord, my junior, my lord, prayed for time on my ground.
Petitioner.
I am for the, my lord, respondent.
Who is your petitioner?
My lord, Mr. Mrinal Kanti Ghosh.
Where is he?
Friday, my lord.
We sat because any
My lord.
motions are there, we would have taken up. We have sent a notice to the bar.
My lord, in the event, my lord, this matter, my lord, has no urgency per se.
ये पाठिয়েছো তো? What can? Come tomorrow, let us.
My lord.
Item 53, Millard, fixed at 2 p.m. Mr. Mojumdar is here, but no matter, Millard. Kindly fix it any date, particular.
Let it be in the list without the date so that it can appear in the next list. Fixation of time, you mention, we will fix. Because
On
we have-
reopening, my lord, I will mention it. On reopening, I will mention it.
reopening, let us know, we will fix it.
My lord, item number 66, I am for the petitioner, my lord.
Yes. Who is your other side?
My lord, kindly make it not today, my lord. 65. My lord, item number 48, my lord. I am for the petitioner. I pray for not today, my lord.
Why? Your senior is not here.
Yes, your
What
yes,
is the
my
matter about?
lord. That matter was pending in the tribunal.
Early hearing.
Yes, your lordship. The tribunal.
আরে এইটার ওই যে ইয়ে মেনশন করলো না যে কি নাম? রায় ওই যে আগের দিন এসেছিল না, আমরা বললাম অ্যাসাইনমেন্টের কন্টেম্পটের ভিতর আছে। হ্যাঁ 16 থেকে কালকে লিস্ট ফ্রেশ ম্যাটার।
Yes, not today.
তুমি এই রেস্টোরেশন তোমার যদি WPST WPLFT কিছু থাকে তুমি খুঁজে নাও, খুঁজে নিয়ে আমায় দেখবে না দিয়ে এই অ্যাসাইনমেন্টটাকে উপরে এই অ্যাসাইনমেন্টটাকে উপরেই দিয়ে Nobody hears here in the motions.